invest in my future, I'll invest in the purse. I wanna be so rich, life changes, and I don't ever think about how much I just pay it. Yeah, it's the dream, the American dream. Live on top, don't stop till you got everything. But there's balance, cause this life is a challenge. You gotta live in the now while building up the talent. I'm the type to make commas, turn a profit. I'm the boss, Willy Wonka, but it ain't chocolate. Yeah, I'm just being honest, I work for this shit. I'm usually modest, but this beat lit, so I'm going off thoughtless, talking my shit. Yeah, I'ma be the hottest designer in drip. I'm just coming with the rawness. I gotta admit that I'm usually modest, but I work hard for my shit. It's not about the destination, it's about the journey. So keep working till it's hurting, cause that's when you start deserving everything you want, everything you need. Trust the process, yeah, you got this. Keep on working till you bleed. Yeah, I've been there, yeah, I've done that. 10 long years of breaking my back, but now I'm up here, never looking back. I got more dreams that I wanna go attack. Keep on going, keep on moving, never give up. I'll keep going, I can prove just what I'm made of. I got that fire in me, got that desire in me. I'm never tired, I'll be pushing till I'm finally free. I was made to break away from the pack, to challenge, to fight, and to carve my own path. This world wasn't made for the weak, they don't last. Survival of the fittest, so be vicious and attack. I'm the type to make commas, turn a profit. I'm the boss, Willy Wonka, but it ain't chocolate. Yeah, I'm just being honest, I work for this shit. I'm usually modest, but the speed lit, so I'm going off thoughtless, talking my shit. Yeah, I'ma be the hottest designer in drip. I'm just coming with the rawness. I gotta admit that I'm usually modest, but I work hard for my shit. I like to get paid, that's why I work every day. I'll be making money till I'm in my grave. Don't care what they say, I'll buy time with my money. Laughing to the bank cause it's funny. The money keep coming, I manifest it. Sing these lyrics and you'll get it. I'm the bank, come invest it. I get tracked and I have it. Money finds me attractive. I'm the type to make commas, turn a profit. I'm the boss, Willy Wonka, but it ain't chocolate. Yeah, I'm just being honest, I work for this shit. I'm usually modest, but this beat lit, so I'm going off thoughtless, talking my shit. Yeah, I'ma be the hottest designer in drip. I'm just coming with the rawness. I gotta admit that I'm usually modest, but I work hard.
Hello and welcome to the Marko Yamashita Show. I am your host, Marko Yamashita. Very, very esteemed and quite... I did not even get 5 minutes past the community post that I put on the channel here about what I was going to be doing today before I came along. I came across False-Eyed in his video here regarding Nijisanji, the streams that have happened over the last couple days, and yeah, I mean, I'm sorry to say this, but he's full of shit. Okay. And I don't like calling people out like this, and the effect of False-Eyed is somebody who portrays himself as bringing information to the masses of people who are, providing insight and information on the greater topic at large when it comes to VTuber news. And he is basically the Fox News to the VTuber industry in many aspects, because this is so egregious that I literally decided that I'm going to stay awake at 4:30 in the morning to stream and talk about just how full of it this entire stream, this entire video is that he put up about the case. All right, because number one, he does not specify the fact that the attorney in this video is not providing he is providing information based on assumptions, all right? And the presenter in this video, Mr. Esquire, says that up front, that that they're basing everything that they're talking about based purely upon his interpretation of what is being presented, but he cannot provide an accurate Japanese law type of interpretation of how things are actually, can actually play out, because Nijisanji and Any Color are based in Japan. All right. Now, an argument is made that, yes, just because they are in Japan does not mean that Dokibird doesn't have legal alternatives that can be filed on behalf of her from Canada to Japan. However, False Eye completely leaves out all this information, and he automatically goes in and tries to get the kill shot so he can get views and clicks onto his video of Nijisanji is just destroyed by this lawyer, and it's over and it's done with, and so on and so forth. And we're gonna talk about this because there's two very important things that both this lawyer and False Eye do not talk about, which are relevant towards this case. And I am not an attorney. However, I have the capability and foresight to actually go and try to do at least a little bit of research about what the fuck I'm talking about before I open my mouth and be an absolute ass like what he's doing. And excuse me for throwing profanities at him, but this is not the first time that he has over dramatized and sensationalized a situation that has been occurring, and he has no idea what the hell he's talking about, and it turns out to be completely false. And he is misrepresenting the things that are occurring, which could lead him into trouble should Nijisanji and Any Color decide enough is enough, because he is currently doing exactly what Dokibird is accusing Nijisanji of, and that is defamation of character on the internet through either verbal or written communication. All right. Now, I want you to see what Mr. Howlex. Welcome to the chat. Nice to see you. Nice to see you here. So we're gonna talk about this, all right? We're gonna go through this a little bit line by line segment by segment, and we're gonna discuss this.
That is the question being asked today about Dokibird, formerly Selen Tatsuki of Nijisanji English, now terminated from that organization nearly 2 weeks ago. As now on the case is Legal Mindset, a Florida man lawyer looking at this particular case piece by piece and drawing numerous conclusions, while being joined by Gator, aka the Gator Gamer, for VTuber expertise. Legal Mindset here giving his opinion on the contract termination being tweeted out.
Okay, number one, first, this is an opinion. This is not legal advice, nor is this conclusion relevant or hold any water in a court case relevant to this situation. What he is stating here is, number one, based upon his ignorance of the actual law that is currently in place in Japan, and his interpretation solely upon his practice, which includes the United States, Canada, and some situations in South Korea. All right. None of this is relevant because he, in a court case which would first be in Japan, which he has never practiced law in and does not have a full understanding of what the laws are in this regard.
Is inviting a legal nightmare as corporate counsel. Like, people know me from doing representing special districts as well. I did that when I was younger as a younger attorney in Florida, representing Reedy Creek, which is why I covered the Disney issues. But later on, I was corporate counsel for a very large corporation. We would never post a notice of contract termination.
Okay. And this entire opinion is based upon him being a corporate counsel in the United States. All right. This opinion is also formulated based upon how law is practiced in the United States. This does not preclude or give any kind of narrative stating that what Nijisanji did is wrong or is afoul of current law.
This is insane, right? This goes to her lawyer. This goes to her, right? That's about it.
Well, here's the kicker. It didn't even go to her. She did not find out that she was terminated until a friend of hers messaged her and said, hey, what's going on? I just got this thing about you getting terminated. And it just, imagine like finding out that you got fired from somebody messaging you.
And now,
okay, now he cuts it off there. Okay, number one, Dokibird had the understand she was already put on hiatus before this notice goes out. Okay, number two, she had already been making threats towards Nijisanji about stating that she was going to publicly disclose information about this situation before the notice went out. Okay, so she's already making threats and dropping ultimatums towards any color. Hey, you negotiate with me, or I'm gonna talk publicly. Okay. So, and number three, she made herself unavailable to have this information communicated to her because she decided to try to make an attempt on her life. Okay. Now that could be there could be an argument that because of the situation, her mental state of mind was impaired and they are the cause of it. So there may be a case for that. However, you cannot hold a company liable for, doing it, terminating you when you yourself make yourself unavailable. Right? That's just how the law is. That's just how law is. A company is not required to personally notify you first before terminating you. There's no law on the books that say, anywhere that says, you have to inform the employee of termination of their employment before you post their job or things of that nature. Okay.
Further on the subject of Selen Tatsuki's contract and where that jurisdiction lies.
What they're saying here is, okay, we terminated Selen, and I am going to summarize, due to breaches of essentially their rules, right, of their policies. And that would amount to breach of contract. Now, that is something I'm generally familiar because breach of contract is fairly international, right? The rules regarding a lot of other different types of law, criminal law, even certain types of civil law are different, but breach of contract is actually one of the things that's pretty international. And just so you guys know, because one of the big issues is venue. With breach of contract, typically you look at where the defendants headquarters is, where their place of business is, and also if it's stipulated in the contract or stipulated anywhere else or wherever the work is primarily taking place, which clearly would be Japan. So for the breach of contract claim, the venue would definitely be Japan. But that does not preclude Selen/Dokibird from bringing other claims in Canada that are not available in Japan.
Next, we have the topic.
Now, and on that note, you also have to look at facilitation of laws when it comes to being in a different country and how it is applied to an entity that is based out of the immediate jurisdiction. In a sense, Dokibird would have to compel the government of Canada and or whatever province that she lives in to enforce said law in order to win any law case that happens in the jurisdiction of Canada. All right. Just because she takes a case to court in Canada and say that she wins does not automatically mean that Nijisanji has to comply to that court case ruling. The government itself would have to apply the law internationally and state, because our laws can be transferable and we have an agreement with your government, you are hereby compelled to obey the resolution or the verdict of anything that is brought to court in Canada. All right. And that basically means that you are going to be drawing out any kind of legal issue for months, years, who knows? I mean, if she can't wait for Nijisanji to review her video before it is uploaded within, what she feels is a timely manner, is she going to even have the patience to wait? and hopefully Canada can put the pressure on Japan to say, hey, this company wronged my client, they need to pay up. Honestly, I have my doubts on that. All right,
of potential defamation.
But even here, guys, what they've said is already pretty defamatory if it's not true. And there's some of this that even with what the facts that we've seen so far appears may not be true, right?
That's based on pure speculation. That is not based on actual fact. Okay, that is based upon speculation of things that are implied on the internet through a Reddit super mega thread post and various other tidbits that they are drawing upon. There is no actual fact on that matter.
So, and once again, guys, I know a lot of what's out there is like speculation.
Exactly, it's speculation.
Right, Gator?
Right.
Certainly there's a ton of speculation out there. But it seems like if we talk about this line here, which I would be concerned with, infringement on third-party property rights. My understanding, Gator, and correct me if I'm wrong, is that she, in reality, did not violate anybody's copyright or IP laws, that she had permissions for everything that she did.
Right. She even reached out to the original author of the song that she used, Lily Pichu, and got her explicit permission.
Okay, and I'm going to stop it right here because basically this entire line of dialogue here that's currently happening, and and is going to continue to draw out for a little bit is completely moot and besides the point, because number one, she broke the rules of workflow that are spelled out to her by her company. Number two, just because a talent claims that she has permission from the copyright holder does not mean that the product or the project that she was uploading had been cleared by management. All right. There is a specific workflow that has to happen, and Nijisanji and Anycolor must ensure that they are not infringing on another company or entity's copyright before they can put anything up on their site that is not original. Okay, and I cannot stress that enough, and I don't know what it takes to get people to understand this, all right? Just because she goes out and says, oh yeah, I have the rights of this person who made these assets for me, I have their permission, even though she may have gone out and gotten the cover license in order to do a cover song of a specific song of a specific person, does not mean that she has cleared the prerequisites that are spelled out by her employer. Because it's, at the end of the day, it's not her ass that gets in trouble if any copyrights are broken. It's Anycolor's. All right, and there is a huge distinction between you being an individual or independent VTuber and going through all these checks and balances, and then working for a corporation that has the same checks and balances, but those checks and balances are within a hierarchy that you must follow in order for things to happen the way that they need to happen. I mean, it's the same way in Cover Core. It's the same way in Production Kawaii. It's the same way in Prison Project. Regardless of where you go, these checks and balances exist, and you must have all your ticks in the box and all your I's dotted and all your T's crossed in order to get or put a cover song or anything that involves a third party up on your corporate site and your corporate channel. I don't know how else to stress this, all right?
And was actually working behind the scenes trying to get management to just kind of give the okay and reach out to these people. They didn't do it. So
see, there we go. In the very next sentence, he's already making this a moot point where she was trying to get her management to release the video, go and ensure that everything was correct. And it wasn't that they wouldn't do it. It was that she would not wait for them to approve it before the product went up on the channel.
On her own behalf, she went and talked to these people,
and this right here does not matter, because unless those approvals are specifically run through and verified by management, what she all these things that he's claiming that well, this happened and this happened and this happened and this happened, none of it matters. Because unless management has that proof in their hands, in their sweaty little hands, it doesn't matter. They have to be able to see it, and they have to be able to say, okay, we have everything we need. We can release the video.
Got the permission to use all of the assets, to use all of the art, to use the song.
Further now, we have a debunk.
And see, and here we go. False Side doesn't even bring up the rest of the story here of the fact that there's an entire second side of this story that he just completely omits, because this is pure clickbait on his side.
Of the doxing claim.
Factually, so the information they're talking is information that was exchanged between lawyers and to the company. There was no threat of doxing there. There was no threat of public exposure, right? There was no, as far as we know, right? I have not seen any proof of that at all whatsoever, right? At all. If anything, I think probably Selen has more reason to be worried about doxing than the Nijisanji livers, like these three Nijisanji livers, because they clearly don't give a shit about personal information. They're just passing it around and not really caring who they get.
Right. This is pure speculation, and this is also inherently false, okay? Because we know beyond a shadow of a doubt that Selen named specific livers by name and included their where they live in the document that she had sent to Nijisanji in her in her grievance that she had sent through with her attorney. Now, if anything, and I'm going to turn this around, because if anything, and this lawyer, this attorney, is again ignorant of what the laws are in Japan. There are specific laws in Japan that specifically address personalized information in relation to what is called a pseudonymized name. And these laws have a specific weight to them because they essentially address the situation that we currently have. Obligations of businesses handling pseudonymized personal information, okay? These laws are specifically in place that so they allow companies and organizations to talk about specific information without specifically identifying who they're talking about. Okay, this is why Mafu was able to go and talk about Rushia, or Mikineko, in an article, and why he was able to go on Corey's channel and talk about, Aiko-san, or whatever the hell that he said, that pseudonym that he used to talk about Mikineko specifically. That is how you get around these said laws. All right. So whether or not they discussed her or they saw a document or anything like that is completely besides the point, because the termination notice that everyone's in an uproar about, that you go back and try to point to as the main key piece of evidence of slander and defamation against her, doesn't even matter, because they never once allude to her as a person in a personal sense of her being the person, because they only reference the IP name of the character that she uses, aka a pseudonym of her as a fictitious character that she portrays. And it's not actually her. She's the one that divulged that said information is potentially about her. But again, she disclosed that information before everyone else came out and said, yeah, this might be about her, because she portrays said character. So you cannot make this argument here without looking at what the laws are in regards to pseudonym personalized information. Because if the document and anyone else refers to Dokibird as said character, that's all speculation until she came out and said, yes, this is about me when I portrayed this character for this company. All right. That means she outed herself about personalized information, and she freely shared it on the internet. All right. You have to look, and again, legal mindset. He never once references this law. He never once references what the actual articles state about pseudonymized personal information and what legal responsibility Nijisanji had in regard to that. And this is how they're able to post up on up on their website and make these statements saying that we terminated Celine, because they are not talking about her, the person. They're talking about her, the character. They're mentioning only the character by name and the actions that were taken by the character, by the person that is portraying a character, and while they are in character, because they are utilizing their IP when this happens. If anything, they properly disciplined her for breaching of her contract because of the code of ethics that they listed in in their contract that they have to abide by. Beavers, welcome to the chat. Fallside really got lazy there. Yes, he has been extremely lazy with this, and this is completely, this entire video. Well, I didn't watch this entire video because I got about 5 minutes in, almost to where we are right now, and I got so sick of the BS that he is spinning in this video without actually talking about the entire subject, that basically he's implying that legal mindset literally just took to task everything that Nijisanji stated, when legal mindset doesn't even have half the facts right, and then he doesn't even know the laws that are applicable to this situation. And all you have to do literally is do a Google search, and you can pull up these laws and these bylaws and these acts and these articles, and this entire concept that who is actually being talked about here gets summarized with the fact that they're handling and talking about a pseudonymized person who isn't real. They're talking about a character that's being portrayed. Yes, they terminated the voice actor that is behind the person, but they never mentioned her by name. They mentioned the character, which they own, and is a pseudonym for her, which they don't have the same legal boundaries of, a celebrity name or all these other things. And even if they did, she would need to own the Celine name in order for any actual, disclosure of information, so on and so forth, gets applied to this. No, they're talking about the employee. The contract is with the talent, not some character. Oh, they're talking about the employee. Yes, they are trying to talk about the employee. Okay, they're trying to characterize this, their conversation about the employee, about the person, right? But the information that they're trying to extrapolate and talk about is about the character. Okay, go back and read the entirety of what is in the termination notice, and they never once mentioned her. Even when they talk about, with her health and mental and physical health and mind, blah 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 blah, they never once use information that it specifically talks about her, the person. All right. They, they never once use her real name. They never once allude to any information that can actually identify her. I mean, we would basically know that she's a female, and she tried to do X and Y and Z and ended up in the hospital. Okay, that narrows it down to 100,000 people, maybe, to 500,000 people. There's nothing identifiable there. All right, and then again, number two, the other argument is that what they said. Well, they shared that document that was supposedly held in confidence, that would be classified or non-shared in the office, or whatever, however you want to terminize that, right? But the Legal Matters actually talks about that situation as well, and Falsi cut out the entire part where they talk about how lawyers in Japan are not held to the same code of ethics as what lawyers and attorneys are held to in America or in Canada or in Europe, for that matter. They're not held to that same code of ethics of confidentiality as what us in the West are used to. That doesn't make it right. However, if that's the way that the law works over there in Japan, then again, since they are a Japanese-owned company, they're not legally bound to that same code of ethics when it comes to sharing information, especially if that information is delivered to their legal department, and then that legal department files or starts an internal investigation about the supposed hazing and bullying and harassment of employees. You have to literally tell them, in not so many words, hey, we have a grievance here that you've been bullying somebody, and you literally have to be able to talk about them as an entity and person that's filing said grievance against supposed actors that did something bad in their company, that and they need to have disciplinary action against them. How are you supposed to address an incident of hazing and harassment and bullying if you can't even talk about the person who is making the claim? I mean, that you can't properly investigate something. I mean, that's basically like, going out and saying, okay, yeah, somebody shot me. Well, who shot you? Well, I can't say their name because, confidentiality. I mean, it just doesn't work that way. That guy over there, that guy that looks like this, does this, was wearing that. Oh, I am identifying that person based upon his looks and appearance. That's all personal information. That's how he looks. I am racially profiling him. I mean, you see how ludicrous that argument does not hold water. It does not hold water, So I mean, and I get that. I get what people are trying to say in response to this. However, again, we have to look at the fact that this is a Japanese-owned company. The information that was handed from Doki to Nijisanji that happened, in the jurisdiction, which Legal Mindset has already stated that, it would likely fall over in Japan as opposed to any other entity or country first. And you handed it to a legal team and attorney that is in Japan that are not held to the same code of ethics that the rest of the world typically has, or at least the Western world. Let's see here. Legal matters and part 2 use the personal information electronic PIPEDA to explain how Doki legal team might So CJC, that thank you for bringing that up. Now, I haven't been able to watch part 2 in its entirety because there's just a lot of material to go through on this, right? However, the law that as it stands in Japan, or rather this is the law. It's called the Act of Protection of Personal Information. All right, that this is all a translation of the law that is done by the Japanese and put up on a Japanese site for people to consume. Right now, according to people that have analyzed the law and tried to interpret the law, their act here that we are currently looking at does fall in closer to the PIPEDA laws and documents as opposed to HIPAA. All right. And as Legal Mindset has also stated, there's a lot that people just assume, is contained within HIPAA. However, that's a misunderstanding of what that law covers and what it doesn't cover. And same with PIPEDA, and same with this law as well. If there was never any document that was signed saying that that the employee is going to hold the employer accountable for personalized information that they have in their possession, you have to sign off on the document stating that with an agreement between yourself and that other entity, stating I understand that these are the laws, and at any time, I can request this information. I can request them to delete information. I can request them not to share specific information, so on and so forth. If you don't sign any documents to that effect when you're signing your contract, they may not necessarily be bound by any particular law stating that they have to do that. There has to be a written agreement between yourself and that other entity in regards to disclosure of information, and also the fact that you have to actually know what applies and what is not applicable when making that charge against the company. Otherwise, that falls directly within defamation, which they have talked about here before. And I would like to I would like to again bring up the fact that defamation here. Okay, this is the actual law of that defines defamation. Okay. This is the actual law held and shared out by the Library of Congress here in the United States, that is translated into English. Okay, defamation is an expression either by word or in writing designed to bring injury to another's good fame. No distinction is made between libel or slander in Japan. Okay? So she would have to prove that what they have said and what they have released was designed, intent. You have to be able to prove intent of that other party, that they wanted to bring her harm against her good name or her fame or identity, right? Under the Civil Code, defamation constitutes an unlawful act for which monetary compensation and or other suitable measures, such as a public apology for the restoration of one's reputation, is required. Okay, this is why you see people all the time that are Japanese talent. They come along, and something happens, and then they automatically make an automatic apology, and they own, whatever situation there is, and then they let everything, play out behind the scenes. Because if they come out and make that public apology, that can be used as case closed of an instance of defamation. Now, a case can be made that with Falside's statement and his video here, it could be used against him as defamation against Nijisanji, because this law is held to the standard of the individual, the person, as a person, yourself, or an IP, or a company. All of it is applicable. There's no distinction there. And the fact that he comes out and is saying, yeah, there's all this evidence that against Nijisanji, and this lawyer just destroyed him, and look at all this evidence, and he's been mischaracterizing everything that legal mindset has been said, by the way. Nijisanji could actually go after Falside and say, this is defamation of character against our corporation, and you're causing us harm and damage to our reputation. Sorry, my voice is still waking up. It's 4 o'clock or 5 o'clock now. And this thing just annoyed the hell out of me when I watched it. Let's see here. I feel like Nijisanji was more concerned about Celine's graduation than Cup of Coffee, because I doubt Japan would copyright strike Nijisanji when the creator was cool with it. See, but that's the thing. Thank you for bringing that up, Beavers. By the way, that's the thing, though. See, when you upload content to YouTube, there is an algorithm that automatically scans the video. All right, and it uses AI. It uses AI detection to identify potential copyright, either copyrighted material or copyrighted, pictures or sounds or so on and so forth. And if you upload something like that, it also automatically alerts third parties to the fact that property was used. All right, so in a sense that they're looking to cover their ass. That's why, like, when you look at the at the description section here, especially when it comes to like songs or cover songs or other, video type stuff like that. You will often see like a reference to the original song or the original creators or whatever. That's all done automatically. All right. Then you have to go back, and then you have to be able to manually check to ensure that you are not being restricted of the you're not being restricted by YouTube for the content which you're uploading. So you have to go through these checks and balances, regardless of if a creator was cool with it or not. Because if it gets flagged and it gets demonetized in any way, shape, or form, you lose the entire time in which that video was released. And from time of release, you get what's called a you get kind of like a tail. They basically call it a tail, all right? And basically what that is because within the first 48 to 72 hours is when you get the most amount of traffic for any content that you put up. Any video that you upload to YouTube, you get the most amount of traffic. 99.9% of the time, you get the most amount of traffic within 48 to 72 hours of that video going up and live on your channel. Now, if it goes up and then it gets restricted or copyright struck or anything at all, which restricts the amount of traffic that goes to it, you're automatically hurting the best period of time in which you either make a profit off of it, or that you're making your ad revenue off of it, or or your reach, for example. Because sometimes when a song goes up or a particular piece of content goes up, it may be restricted in certain territories. So you have to be extremely careful and mindful of these things, which is why there's a process in which they have repeatedly said that she chose not to follow, and in return has had disciplinary action. My mind went blank there for a second. Against her for not following those workflows. But that's a great point. Whether or not the creator was cool with it, and she had those permissions and things like that. That's what Nijisanji is worrying about their own ass, because in their mind, for whatever reason, in the apparatus that is the process that they have, they did not think that they had all the approvals necessary for that video to go live. We hereby announce that we had to make a difficult determination to terminate our contract with Nijisanji Liver Celine Tatsuki effective immediately. The first line talks about this liver. Okay, Zetsu, thank you so much for dropping in and being part of the chat. Okay, that's a great thing that you brought up. Okay, now number one, again, when that line, that particular line, and all the other references in that document are referring to their IP. Okay, Nijisanji owns the name. They own the name Celine Tatsuki. They own that name. They own all the rights to that name. so they can talk about them all they want, because number one, they own the name, they own the property, they own everything involved with that name, because it's their property. She is literally she's voicing said person, but then you have to look and take into account that, again, it's a pseudonymized name, a pseudonymized person that she is portraying, right? The laws don't necessarily apply to pseudonymized people when it comes to talking about them. That is why people like Mafu was able to reference Mike Nico as, I mean, in America we would call them person X or Mr. X or Mr. Y. That this is exactly the same thing. The only difference is they own the name, the person, the likeness, and the portrayal of said person. So when they say, we are terminating this liver that's named this, they are literally cutting ties with the name, and they're retiring it. That person is no longer under contract. Basically, they're saying that, as of now, this fictional character no longer exists in our universe. That's why they erase everything that is involved with that person, and why all that work that they have done, is, taken off the shelf, and Dokibird can't really reference those things and say that this is my portfolio of work, because she doesn't own any of that of those things. So Nijisanji, excuse me, they have every right to be able to talk about what is happening with said name, because the portrayal of that name happens because they produce it, not because it is Dokibird, but it's because the name and the person, the identity, belongs to them. Do you understand what I'm trying to say there? I hope you understand. All right. If any color wants to keep their livers in the company, they need to care more about whoever's left. Yes, that is the case, and I completely 100% agree with it. And I personally would tell them, if I were advising them, I would say, you need to look. Number one, okay, if we were to talk, hypothetically about how Nijisanji should fix this situation. Number one, I would say no longer reference Celine in any future releases or of information or comments on it or anything else like that. Let all that play out in the courts, if that is the way she so desires. All right, because anything that she puts out about Nijisanji and her employment there will again fall under the law of defamation in Japan, which they can use against her. All right, I'm not defending Nijisanji. What I'm doing is I'm trying to help you, everyone out there, understand that what Falseye is saying here is basically making this sound like a slam dunk, in that it's over for Nijisanji, and burn the yacht and let sink to the bottom, so on and so forth, when that's clearly not the case. When you have an attorney who, number one, does not have all the facts in front of him to make a better educated opinion of the situation, and number two, is only providing his perspective from a Western American / Canadian point of view, you're only talking about half the story here, because you have to look first at what the laws dictate and stipulate in Japan first. Okay, now if we are going to talk, how are we going to fix Nijisanji? What should we do? Number one, let this all play out in the courts. Never talk about it again in public. There's no need to make public statements about it. Okay. Number two, I would take a complete look at what the workflow is in its entirety, from liver all the way to management, when it comes to product production, when it comes to producing of content, getting approvals, making sure that you have all the licensing and all this other stuff. Look at the entirety of that process and say, how can we do it better? Do we need to hire more management to handle our livers here? Because that could be a case we talked about yesterday, where there is approximately 10 livers per, if the average of what is dictated in their physical report is any indication, there's approximately 10 livers per manager, assuming that the averages between each department is correct, and we're making a guesstimate there because it does not specifically say how many managers there are, but they do give an overall number of what the support personnel is for livers when it comes to making content. Excuse me. So, if that number is correct and there's approximately 10 livers per manager there, you need to look at that process and say, okay, how come this is taking so long from liver to management before we can release content? Because time is money. I mean, you have to look at refining the process. If it's slowing things down and you're having to deal with stuff like this, it costs you money to take care of this stuff. How can we fix this? What do we need to hire more people? Do we need to cut out specific bulk within the process so we can get that information and that in our hands quicker, or so we can get our produced products uploaded to the channel quicker? What can we do to ensure that we produce the best amount of quality while still having our checks and balances to cover our butts by through legal means and through use of third-party assets and intellectual property, and copyright laws, so on and so forth. Right now, in order for that to happen, you have to be able to number one, take constructive criticism, and number two, be willing to say, admit that there's a problem. I think with the amount of dust up that has happened regarding Dokibird, they would likely be listening a lot closer now than they were would have before. So I would actually encourage any of the livers out there, say now's your time and your chance to speak up. So you can bring your concerns to management now, and now is the best time to do it, because now would probably be the best time to encourage change that is happening behind the scenes. Now, the second thing that I would tell them, I have this gut feeling that they have this mindset of quantity over quality. And because they're trying to throw the biggest net out there to grab the biggest crowd that they possibly can, you're going to get a lot of misfires like this, or like the people that have left, or, especially the ones that have left under controversial circumstances, people who's like, nah, this isn't for me, and they left and went back to do their own thing, that kind of thing. I would say, like you mentioned it in chat, focus on those that are remaining there, build them up and establish that project based upon who you have left before, and cultivate a better work environment before you hire more talent to join your ranks, because there's quite clearly a problem here. All right, and I'm not being dismissive of that. That there is it's really evident that there is a problem here, and between what corporate is looking for and what is actually happening. And until you are able to meet, part way and clear up that, all this happening that shouldn't be happening in order to make a better product, it's going to keep happening regardless if you hire 10 or 20 more people and come in and say, okay, you're now part of Nijisanji En, and you haven't done anything to try to remedy, the obvious grievances that are out there from past and present talent that have worked there. Let's see here. In my understanding of PIPEDA, Doki must submit documentation with IRL traceable origin, meaning name, address, even medical records. So PIPEDA does cover name, address, phone numbers, Social Security, or whatever the equivalent might be in Canada. I don't remember what that's called off the top of my head. Yeah, there are identifier numbers that can be tied to, said person, right? Now, all that can be traced back to a person. So you have to when you're employed, you have to submit that information to your employer. That gets handled by HR. And you also have to if you're trying to fight this legally, you're also going to have to put your actual information in said legal document. Now, said legal document that was the grievance that was handed to Nijisanji implicated other livers that legal mindset and the livers themselves said that they were specifically named and called out. The company has an obligation to inform those talent that they are being included in said grievance because they are employees of said company which they are representing. All right, and again, there is no statute of ethics or anything like that preclude them from saying, we can't discuss the specifics of this because X, Y, and Z, when they're being implicated in said grievance that is being brought against the company. Because number one, they're going to have to, if it goes to court, they're going to be called up to the stand. Number two, that there's going to be evidence that actually, calls them out. There's going to be communication that, that will have to be submitted as supposed evidence, which means that they, Dokibird, by releasing that information of private conversations, is also exposing personalized information of that talent, which could be turned around and said, you're doing the exact same thing that you're claiming that my client is doing. You can be countersued for this. And not only that, if she is implicating other talent within Nijisanji with supposed evidence, that also can hold her legally liable for defamation of character, because she is basically defaming those people that could prevent them from being employed at the company, or it's being detrimental towards their their performance while they're working for the company through this entire ordeal. So I mean, you see what you see, this rabbit hole that we're chasing down here. I mean, everything that she is claiming that is happening to her from the company can be used against her. And what you end up having is you either end up having a stalemate where you sue and then you counter sue and nobody wins because everyone is held liable, or they're able, or said company is able to use what you're presenting as evidence against her, which essentially is making her testify against herself. But I mean, that's when you have to go back into the pseudonymized information, names and identities and so on and so forth, which is a rabbit hole in itself. And you spend years trying to get this case cleared in court. I mean, I want people to understand that what Fallside is promoting here and what he's putting forth here is in fact only part of the story. So people are looking for updates on the situation, and they see his video, oh yeah, this lawyer destroyed Nijisanji. I mean, the case is already won for Dokibird. No one has to worry. I mean, everyone was right. Nijisanji is this terrible company. When in fact the information is much more complicated than that. And it's not. He did not destroy them. When you can take these two documents here, the Defamation Law from Japan, and take the Act of Protection of Personal Information Act. You can take these two documents here, and you can essentially refute everything that Legal Mindset is saying during these clips and sound bites, because he's only speaking by his knowledge of law as it's interpreted by a Western attorney that does not practice law in Japan. So he's more credible than most people to voice an opinion on this situation, but he is not like somebody who knows the law book backwards and forward in Japan and can win the case purely based upon what he knows. He's not like that. I think LM also said difference in law culture because miscommunication. Yeah. So not only do you have the cultural difference in and the way employment works in Japan, but you also have the cultural difference between what her lawyer may or may not do versus a lawyer in Japan, and how they handle information. And that's another extremely good point that you're bringing up. The Cool 2T, welcome. That's a very good point that you're making, because if you're a history buff like I am, and you go back and you watch documentaries on the Nuremberg trials, when after World War II was won in Germany, and a lot of the Nazis got captured and brought in front of a tribunal. The Nuremberg trials are a perfect example of what is currently happening, because when the United States, when the legal people that were prosecuting the Nazis during the Nuremberg trials went up and tried to make their case, the third in command that was it the third in command? No, the second in command, right? The person that at the time was the deputy Führer, the deputy guy underneath Adolf Hitler was brought in front of the tribunal, and he ran circles around the U.S. attorney, and the reason for that is because of the way that the laws were applied by the United States, and the code of ethics that were that the attorney from the United States was trying to abide by, that represented our country. And after he was unsuccessful, with trying to make his case, the Russian attorney came up and made his case against the deputy Führer, and he completely annihilated the arguments that the deputy Führer was making in his defense, because the code of ethics that the Russian attorney followed is completely different than what the United States attorney was able to present. So you have to look at, number one, jurisdiction, number two, how the law is applied, and number three, how those laws that apply in Canada are interpreted by international law when it goes to translate to applying the Canadian law against a Japanese entity. Because if the international agreement between the companies precludes anything of this nature across borders, she can file a suit in Canada and win. But if the laws, if the agreement between Canada and Japan does not stipulate that law can be applied to a Japanese entity that is not a business or a person that resides in Canada, if there is no agreement within that law transition, that agreement that that they sign, it doesn't matter whether or not she wins in Canada, because the Canadian courts cannot compel a Japanese entity to follow the law and the law and decision that is made in Canada. So you have to really look at all these different factors, and you can't just come out and say, "Yep, legal matters, Mr. Esquire, completely annihilated Niji. Yep, case closed. It's a L, it's an L for Niji. Yeah, you can claim that and have plenty of social media clout by claiming that." And maybe if that's what gives you your victory in your mind, but it doesn't ever translate to any actual action that is levied against Niji. Okay, that's good, but if you're actually looking for reparations, I can't talk this morning. If you're actually looking for reparations of any kind of monetary value or anything like that from a company, and those laws don't apply to a monetary compensation, to when you're filing claim against an entity that does not reside in Canada. I mean, are you going to be happy with just the win and not happy with not getting the reparations? I mean, you really have to start asking that kind of question, because again, everything that has been said towards Nijisanji, as well as her actions. I mean, the Nijisanji could literally take the timeline that has been established and say, from here when she first started slandering our company to here, we lost X amount of dollars because our stock value plummeted. They could literally take that as evidence against her, and it's a tracked system. There are systems and measures in place that actually monitor how much monetary value they lost during that time frame. So they could literally take that to court and say, she did this. We want the law applied to her, and because we lost our monetary value because of her actions, we are filing suit against her for defamation and slander, and they would have a case. I'm not saying they would win it, but they would have a case, and that's purely based upon this one law here. Let's see here. What else is yep, he said that the possible outcome, Doki might need to go to Japan if she continues to push this lawsuit. Yes. You would likely need to make the claim in Japan first. And then if you lose your case in Japan, then file suit in Canada, because the statute of limitations won't even apply here, because of this purely based upon the time frame that things are happening. So I mean, she would have plenty of time to fight this in court. It would be more of a matter of whether or not she actually wants to pay for it, because I mean this is how large companies tend to squash lawsuits that get filed their way. It's because they have more money to pay attorneys and lawyers for the cost of legal action, as opposed to an individual. Let's see here. I think that's the reason why Niji or even Talents thought they were being doxxed, but PIPEDA calls for legal traceable information on both sides. Yeah. Yes, CJC, that is absolutely correct. But the thing of it is, and we don't know, because we don't have the document in front of us. And this is a very big distinction between what we know and what's being assumed out there. All right, we don't know whether or not she named the other talent by their real name and identity, or if she called out the other talent purely by their pseudonym, which would be different. All right, because under Japanese law, there are certain obligations that a business does have to take in consideration when it comes to pseudonymized personal information, aka the pseudonym would, in this case, would be the IP and the character in which they portray and provide voice actor and actress work for. Okay, because that's, at the end of the day, that's exactly what they are. They are They are singers slash talent that portray a character which they don't own. And we can't stress that enough here. They don't own the name. They don't own the pictures. They don't own anything. Even if they go out and get third-party permission for specific assets, including songs, they don't own the overall character, and therefore cannot make a autonomous choice, an autonomous business choice with that character or their channel, which isn't theirs. They work for a company that owns that channel. They can't make those autonomous decisions. They have to follow what the guidelines and rules are that are spelled out in their employee agreement with the company. All right. But yeah, there is an entire section here, and actually it goes on for several sections here, about provisions for and restrictions for pseudonymized personal information, obligations for handling personalized pseudonymized information or autonomized personal information. I don't know whether or not that pseudonymized versus autonomized, that there is a distinction between each term here, where autonomized is basically like, if you fill like a survey, and your IP number may get documented, but otherwise there's no name, address, phone number, social security number, serial number, anything that's that is traced back to you. And even IP addresses don't necessarily provide anybody with actual information, because IP addresses can be faked, just like MAC addresses can be faked. So, I mean, in today's world, that would be kind of iffy. But in this case, there are differences between pseudonymized personal information, aka personal information that relates to a person who is otherwise using a name that is not their actual identity, versus autonomized information, which is information that is given to a company that, and they don't collect, they collect the information such as like in surveys, but they don't collect your personal information along with it. Let's see here. Also, LM tends to find it funny how both Niji statements and actions differ, like how they state they never shared the legal doc, but there is so and thank you for bringing that up, CJC. Now I will in the interest of fairness, I will provide the other side of the argument here before we go on with Fall Side's video here. Now, the other side of the story is the fact that they supposedly shared the document in its entirety, in its complete form, with other people in the office. Now, that there is a case that to be made that depending, again, it depends on how that document and what names are being used within said document, which would constitute a breach of confidentiality and so on and so forth, especially if real names are being used in said document, and it's not like real name as Celine while working for Nijisanji, had had altercations with Vox and Ike, aka so and so and so and so, respectively, and here's our documented proof on it. All right. Now, if it's spelled out to that effect, which it very well might be, because we are talking about a document that was drawn up by a lawyer before it was sent to Niji. She would have the claim of the fact that number one, they took a document that was circulated and applied to that company, which is a grievance, and when you're filing a grievance, it should be handled with confidentiality in mind. And instead of simply discussing said document with other talent, or what was claimed in said document, they actually handed the document around the room, and everyone got a chance to hold it and read it. There can be a claim that that information was mishandled, and that would come back to the law and the act that we're looking at right now on screen about the handling and use of said information. Because even though she was, and this is kind of a muddled point as well, even though she was still employed with the company, supposedly at the time that that document was shared with other people in the company, that the company is held liable for all the information that personalized or pseudonymized, to keep that in confidence so the party can maintain their integrity, regardless of whether or not their claims are factual or not. And that's spelled out in Japanese law, in the law that we are currently looking at. And even if, for the sake of argument, she only uses the livers' names and not their actual names. A case can be made that perhaps some of these bylaws that are in different sections and articles may be applicable towards her claim that that confidentiality trust between her and the company was broken because she was still technically an employee at that time. But it's a very muddled, very up to interpretation type of thing, because what you have to go through Japanese law and look not just at disclosure, not just at business handling of personal information. You have to also take in consideration that there is specific provisions and sections within said law about the business's obligation of handling pseudonymized personal information, because as livers and as VTubers, you are essentially adopting a name and identity that you do not own. And just because something happens to you in real life, it doesn't mean that you can simply go out as so-and-so, as Celine or anyone else, and start slandering or picking fights or making accusations against the company that you work for, because you're essentially defaming the company that you are working for by making accusations. And you're also breaking, specific performance rules that are probably spelled out in her contract. That's why you see a lot of people like Mike, Nico, and other people. They'll go on their alt accounts that are not affiliated with said company, and I believe Doki did do this at some point, and make those grievances out openly. But if you start implicating the company, Nijisanji, or the agency, any color or anything else, if you start implicating other people by name dropping them, you are then breaching that own confidentiality clause, because you're outing yourself as being that pseudonym that works for said company. So there is a specific difference with these with the way things are being presented versus what the law actually is. And we're looking at the law right now. I mean, I'll link this in the description or in the chat here if you want. It's a lot of legalese, okay? But if you want to review, the actual law that applies to this situation, this is the law. It's long. I mean, there's like, what, 40, 50, 60, 70, 80, 90. There's over 100. I think there's like 120, or actually it's more than that. It's 185 articles within said law. Now, not all of this is applicable towards this situation. However, there's 185 different articles that may come into play when it comes to this information, and that doesn't include, again, the Library of Congress law here, which is it's not their law, but it's the law. It's the translation of the Japanese law here, and I'll post, and this will also go into chat here. All right. So you can look at this at your leisure if you want to be informed on exactly what the law actually states versus simply what is supposedly the truth out there, which a lot of people are spinning this the wrong way. I'm trying to provide to you the most accurate picture while trying to remain a neutral party in this, okay? Because I don't have any investment in this. All right, I never even watched Celine or Dokibird when she was active for Niji. I have never watched her. Okay, I only found out who she was because I get news alerts in my email box when something like this happens. All right. Other than that, there was only two people in Niji I even watched. One of them was Pamu, and the other one is Solomon. I watched those two. That's it. I don't watch anybody else in Niji. So I don't have a stake in this. I'm not taking one. I'm trying not to take one side or the other. But at the same time, we have to, because people don't do what they claim that they actually do, they have to be fact checked. And I'm sorry, but False Side is presenting a very, very one-sided, heavily edited, heavily cut narrative here that simply tries to make it sound like there is absolutely nothing that Niji can say in their defense, which is not true. Yeah, there's so many articles. There's just as many articles in that law as hours are in Legal Mindsets 2-part series on this, and there's 6 hours of content just with the 5 to 6 hours with his first video, and I think it's about the same for the second video. Now, a lot of it is back and forth with his chat, so that there is kind of like fluff there when he's talking to his chat, because like you said, part of it of what he does is also try to entertain and do a humorous spin on things as he's presenting stuff, and that's fine. There's nothing wrong with that. However, what the problem starts being is when he's making assumptions based only on what is being presented to him by like what's on Reddit, and when he takes things as gospel without being somebody who actually has been in the VTuber culture, or the idol culture for any length of time, other than his time in he does have the credibility of working in Korea, so he knows like how K-pop is over there, the K-pop culture. But he's only dipped his toes into VTuber culture, all right, and and unfortunately there is a lot more that is muddled within VTuber culture, because it tries to be a blend of streamer slash idol slash technology all at once, and along with anonymity, there's just so much more that's involved with VTuber culture than, say, idol culture. And idol culture has pretty much been spelled out and has been in effect for years. But VTuber culture is still finding its way into its 5th or 6th or even 7th year now. So he has much less of a reference point, is what I'm trying to say. LM says he was just providing a lawyer point of view, but he always asks about VTuber terminology to chat, which I can't actually call accurate info to rely on. Yes, thank you again for bringing it up. Now, I'm going to segue just a little bit here, because I do want to mention this. Let's see, is that still up on the screen? Okay. So I do want to segue just a little bit here, because I do want to mention this to everybody that's in chat. Now, I sent Mr. Esquire, aka LM Legal Mindset, this letter that I composed after watching his first video. I sent him this letter, right? And I'm going to read it out to you right now, okay? My name is Marko Yamashita. I'm a non-affiliate independent English VTuber on YouTube. I've been a VTuber for a little bit more than 3 years, and my channel covers everything from Let's Play type streams to online objective talk regarding current discourse within the world of VTubing. I'm contacting you because recently one of my regulars informed me about your streaming regarding Nijisanji. While there's still a vast amount of content I've yet to review, I noticed the commentator Gator seemed to steer the conversation away from anything that might show quote-unquote fault or quote-unquote lack of ownership / responsibility on the part of Dokibird. Would you be interested in entertaining a conversation between us where we talk or discuss the uphill legal battle she has, and an equally compelling case can be made, I don't know why that says mad, but made against Dokibird based upon the currently public comments that she has made before and since being employed with Nijisanji. My talking points would include, but are not limited to, how to why does that say how to? So it's supposed to say how the termination notice was assembled based upon Dokibird's threatening to release damaging information against her former employer. Contents of the document meant in response to any disclosure might have been leaked by Dokibird. That was what she was threatening in her communication with Nijisanji before they issued her termination notice. All right. Number 2, archived comments passed in public, which allude to a mental condition which Nijisanji could use against her. Past comments from Doki include claims of borderline personality disorder and also her recent incident, which involved hospitalization. Point number 3, claims made via the workflow of streaming content and the rights of the IP holder has to both name and likeness when it comes to publishing it to the public. And this includes all incidents which are chronicalized in the mega thread on Reddit. Point number 5, what is and isn't personally identifiable information when talking about a fictional character she voices, and the only name referenced within the termination document, which is the terminology of pseudonymized personal information, gets heavily implied in recent revisions of the legal document, the legal code, and I posted the link of what I have been referencing to here. And then finally, number 6, since other talent were referenced by name in a legal document presented to Nijisanji, do those talents have the right to know the information contained in that grievance, since their supposed actions implicate them in the complaint? These are just some of the questions and talking points that have come to mind after reviewing the first hour of his stream. All right, this doesn't include a lot of other things that he has said that in the video that I've continued to try to take bites out of because I could talk for hours about a lot of the stuff that he's discussed. If you're interested, please contact me here, which was on X, or my mailing address, which I listed here, which is located on my YouTube channel also. So this is the letter that I've composed towards him, asking him whether or not he would be willing to discuss these things, because Gator does provide some good commentary for the back and forth between him and in legal matters and Mr. Esquire. But he essentially is only regurgitating what the current discourse is out there in public. He doesn't ask questions which would call into he does not call into question things that have been said by Dokibird unless it's relevant to promote her innocence or her case against Nijisanji. He doesn't really extrapolate any of the hidden dangers or visible dangers of what she has done in the public venue when it comes to trying to have any kind of legal case against Nijisanji. All right? That's very important when you are trying to examine and analyze a court case like this. The only time that you would, call it a slam dunk would be, if the case has already been won and the verdict has already been presented, but then they try to appeal it. Then you would be able to talk in hindsight about the things that they are currently bringing up, if it's in fact presented in court and proven to be true. But there's a burden of proof that is completely absent from the current conversation, and there is a burden of proof with the case that is being brought against Nijisanji. The public tends to automatically apply guilty to an entity, especially if they're a corporation or a company, without even going through the case or going through the information or looking at it objectively. They automatically assume the company is guilty of said complaint, and believe that the burden of innocence is on the company, that they have to prove their innocence. Whereas most laws, unless you're in Mexico, you're innocent until proven guilty. All right, yeah, that's an American concept. However, a lot of democracies that are founded that try to mirror the American mindset also apply the fact that that there is a reasonable amount of innocence that is applied to somebody who is a defendant until they're proven guilty. All right. So many Dokibird fans in LM stream during the time he tackled this topic. Actually, it's hard to see and that's just it, CJC. My commentary on this is less about whose side I'm picking on, and that's extremely important. I am not trying to portray that one side is completely innocent and one side's completely guilty. I'm not trying to take sides here. What I'm trying to do is I'm trying to present the best possible picture of what things look like based upon the information that I can pull up with research on this topic, and the current information that is out there in the public venue. Now, a lot of what I say may sound like I'm taking Nijisanji's side on this, but that's only because the narrative is purely speaking from either a Western point of view, or it's purely being talked about by fans or the defendants of Dokibird, and there's no narrative actually out there saying, hey, wait a minute, there's an entire other side of the story here. So we have to be very careful about that, very mindful of that. And CJC and Beavers, I appreciate you guys always trying to keep me level-headed on this, where if I start going more into opinionated type of narrative when I'm trying to speak truth, I appreciate you guys always bringing me back around on this stuff, because that's very important. All right, I don't want to be like Fall Side and sit here and say, this is 100% true. They're destroyed. Bye bye Nijisanji En, so on and so forth. I don't want to be that person, and automatically make a ruling on this when there hasn't even been a court case on it yet, much less a ruling on it, and much less the actual evidence has been presented. None of that is in the public, the public score yet, or square yet. It's not out there.
They give it to you.
And now the question is, has Nijisanji self-reported?
If she has emails, texts for years, prove they lie. Yeah, and we'll see that come out if there's a case, obviously. There's reasons why you don't just drop all the evidence in public. Nijisanji's actually fucking up by self-reporting, by self-snitching, right? They should not be doing this. The fact they're doing this is just, like, mind-boggling.
Okay, so they're talking about self-reporting when they're referring to this case, and again, he's looking at it from a lawyer or attorney's perspective, were it to be a civil case that is under the umbrella of Western laws and rules, right? And what they've done essentially, and I've talked about this before, is that they have itemized why they decided to terminate the character and the talent, because of all these issues that have come up during her employment, and the fact that she made the accusation and threat that she was going to release public information about their conflict. Right now, that doesn't make it right, and this is exactly true, that you do not, under normal circumstances, want to release all these counterpoints that are being made in reference to her and her claims. You typically don't want to release all that stuff, because then you're basically providing all your evidence, or at least some of your evidence, against her, and that allows her attorney to then make a counter argument or strengthen their case based upon what you're accusing her of. But it's not uncommon that the termination notices and reporting of misconduct from Japanese talent, those types of things are reported on and done all the time. Now, whether or not it's legal, or whether or not it's been tested in court, that's a different topic. And there is a wonderful case here that Mr. Esquire has made, where if these things have not been tested in court, does she actually have a case where, based upon the current laws as they are, can you pass it in court, stating that, not only defamation, but also breach of the Protection Act, based upon what they've done, can you take that to court and win that? As far as I know, that's never been tested in court, in Japanese court, where a talent has taken their agency to task in court and won or lost. Now, I do believe that there were one or two cases where a talent did take an agency to court, where they were for breach of contract in regards to monetary compensation, for their work with that agency. That has been taken to court, and there's been like a 50-50 split between whether they win or lose. But I don't believe it's ever been taken to court to test the laws as they are now. Especially when you come to the defamation laws, the online defamation laws, all those types of things, whether or not that's been tested in court yet. So, Mr. Esquire from Legal Matters, he does have a leg to stand on with that argument that, should she take it to court, there may be enough built into the current laws to provide her with a case or a way forward.
It gives her lawyer a chance to look over that and maybe possibly come up with a defense for it.
That's correct.
Exactly. Selin's lawyer can just build the case, right? Or lawyers, because I think she should have a Canadian lawyer and a Japanese lawyer. Selin.
Yes, exactly. She should have a Japanese lawyer and a Canadian lawyer reviewing and communicating on this this issue. That it doesn't mean that she'll be able to win, but at least that you would have the perspective from both sides, so you can then have a path forward on how you want to proceed.
Dokibird, if you're listening, lawyer up in Japan and in Canada.
He just provided legal advice there, even though he said he doesn't provide legal advice on his stream.
And further on, does Nijisanji have bad lawyers?
Jeff Balthazar says, the thing that bothers me the most about this is the whole message doesn't feel like it was lawyer approved. It feels unrehearsed and unvetted. That black message was definitely lawyer reviewed.
That's true. Okay. Anything that is said, that is recorded or documented, especially on situations like this, they always go through management, and they also ensure that through HR and their legal department that the message or the theme that is being portrayed is approved and lawyer proof. I know that for a personal fact because I've talked to other managers, Japanese managers of VTubers, and when it comes to situations like this, they always tell me, before my talent goes out and talks about anything regarding a inflammatory type of situation like this, we always run it by a lawyer. We always make sure that it's signed off, and they say that this information is okay to talk about, and this is what these are the specific points that you can make. These are the things you cannot make. Make sure you do not talk about this or X, Y, or Z. You can mention, you can mention this circumstance or this situation, but this is as far as you can go, and this is the only things you can say about it. Especially since they are not just talking about a sensitive subject, but once again, they are representing Nijisanji as Vox, as Ike, as Elera. They are still representing characters that they portray, and they're speaking on their behalf because they are their pseudonym, or basically their alternate or their alias. So yes, that is absolutely true. Now, the statement that was released by Nijisanji that was posted on Twitter and everything else, that also is legally approved. That any physical document, or and in this case, a physical document is represented by a digital copy of it, right? Any document that is released by a company goes through legal before that document goes public. That's just the way it is. Even if, say, for example, the CEO of any color, wants to talk about a specific thing, and legal says, no, you shouldn't, and he releases it anyways, it goes through legal first, right? Legal will warn them of the consequences within their court system, what the potential consequences are before that document is released. So he's probably going to say, and I'm not, I don't remember what he said right here, but we'll just listen.
I think that their lawyers are not that great. They're like the Disney lawyers, right? And I know this is something that the Nijisanji defenders say. They say, "Oh well, Nijisanji is a company with lawyers, so therefore they're perfect." Wrong.
That is true. They're not perfect. However, that document did have to take a pass through legal. Now, whether or not he's they have good or bad lawyers is a completely different topic, and we can actually, let me just try to pull it up here real quick. Where is my folder? There it is. Whoops. Was it this one? Let's see here. We can actually guesstimate. Where are you? There is a slide here in their presentation that provides a tally of how many cases have gone to court, how many defamation cases they have had over the past year, how many of them went to court, and how many had legal action taken against them. Maybe it's in a different document, but I could have sworn it was this one. Yeah, I'll have to find it later. But they do have a running tally. Yeah, it's probably in a different document of cases that they have actually taken to court over defamation suits, over people illegally using their copyrighted material. I mean, they keep active stats of it, and their legal team is completely active on the front of defamation, both online and otherwise. And those suits have actually increased because of the online Defamation Act that went into effect in 2022 or 23, something like that. So that they perhaps they're not like the cream of the crop lawyers. However, their lawyers have been fairly successful in defamation lawsuits for sure.
I was a corporate lawyer. I can tell you right now, corporate lawyers are not Laffy Taffy. They 100% can fuck up, and sometimes they don't know what they're talking about at all.
That's actually kind of true. That I'll give them that.
They've sat on their laurels, having to do nothing. This is the big.
That is not true. Okay, and again, we know that for a fact because they do actively pursue and had a number of defamation cases that they have taken to court over the past year. So he is making providing an opinionated commentary based without even looking at the statistical activity of said lawyers he is trying to talk about.
Biggest thing the Nijisanji lawyers have handled ever. They probably have no scope of reference for this.
Yes, they do. They absolutely do. And not only do they have a scope of reference, but namely everything that happened with Rusia, everything that's happened with Coco, they also have a scope of reference in regards to the Chinese actors that were that were in effect when there was the huge montage of Chinese actors, and when I say actors, I mean people who were attacking. They're actors, and the reference of attacking other people. They were trying to get as many VTubers banned as possible. They have taken them to court. Not only that, but ever since Nijisanji and Cover Corporation signed a mutual agreement that they would do whatever they can to combat defamation of character, slander, and repudiation for company interest. They when they signed that agreement and had that agreement go into effect about a year ago, Cover Corps themselves have had numerous cases that they've taken and won in court. And where is that document? That document is right. I think it's this one. Nope, that's the any color one. Cover Corporation. And just to show how wrong this comment is, you know, and I'm not saying this to belittle Mr. Esquire here. What I'm saying is, he isn't using any kind of frame of reference in regards to what he's actually talking about. And I believe it's in the appendix here. PL summary. Maybe it's not. Any color has reports on a quarterly basis. Here we go, right here. Activities involving defamation. Activities during the 1 year period from January 2022 to December 22. Number of cases in which actions were taken against defamatory acts towards affiliated talent. There were 116 cases against the talent that were considered defamation of character in 2022. Legal action against infringement rights on online forums, legal action against harassment, so on and so forth. Now they don't give a total tally of cases that have gone to court in this particular slide, because this is only a quarterly report. However, in their annual report, they do talk about exactly how many cases they have went to court, how many cases were resolved, and how many cases were pending. Okay, so all you have to do, there is a point of reference that any color likely has already looked at, and that's basically in cover core. And the fact that if you have 116 cases that of instances of defamation towards cover core, I mean, they only have 86 VTubers on their payroll, and Niji has almost twice that amount. So I mean, a case can be made. Yeah, they have twice. They have the potential to have twice as many cases here. So I find it very difficult to take seriously his comment about them just sitting on their ass and doing nothing. All right. Very much mute. Welcome to the chat. Their legal team may as well versed in defamation and copyright suits, but it doesn't mean they know PIPEDA at the time. Yes, and that's a very good point. Thank you for that comment in chat. That is absolutely true. They may have no idea or concept of how the information law is in Canada. Now, to expand on that a bit, say like she actually does take a case out in Canada, representing herself against any color or Nijisanji, right? Unless those lawyers, are certified to practice law in Canada, they obviously can't represent the company itself in Canada. So that their legal team or any color would then go out and hire lawyers to represent them in Canada, especially since they would want people who know the Canadian law in order to represent them in a court case. But yes, you are absolutely correct. When it comes to the Nijisanji lawyers and attorneys, they may not know what Japanese law is. They know what Japanese law is, but they don't know what Canadian law is. Now, there's also an argument that can be made, and I don't know, how far you could make the argument that since they are a Japanese owned company that is run and operated and based in Japan, that they Canadian law doesn't apply to them. But with them, it's contracting is a very bad way of putting this, because in a sense, you're working remotely from a satellite office or environment, right? You do sign a contract with any color, but it's a talent agreement, and I don't know whether or not if there's differences with calling it a contract versus a employment agreement, or not, because when you look at the grander scheme of things, a contracted employee, Legal Matters has mentioned, they have a larger degree and scope of latitude of wiggle room to act independently, versus how VTubers are working for Cover Core and Nijisanji. You are basically working and representing a company when you are live with said avatar. So this then falls into whether or not what the Canadian laws are with synonymous characters and names, since they never named her by her real name in the termination document. Can the case be made that they basically just fired their virtual talent, and that virtual talent is a name and identity that they own? So she doesn't really have any claim to what she is saying transpired, because it's an imaginary person that is owned by an entity. You see where I'm going with this? Yes, she voiced the character, and herself is was working for Any Color. However, you can't connect her real name and identity to the termination, because she was never referenced as the real person. They only referenced the IP and the name of the IP that was owned by them. That is part of, or at least the major hang up with this, is that they only reference the character. And that goes back to idol culture, where they reference the idol. They don't reference anything else beyond what the idol is or who the idol is. They only reference said idol. The major difference between idol culture, like AKB and everything else, is once they graduate, they can up and walk away with their stage name, and it's theirs. They own it. They have an ownership to it. That's because that's their brand. Whereas in this case, when somebody either gets terminated or they graduate or whatever, they up and leave, but they also end up leaving all the work, the name, the identity, everything with the company, because it's like a lease. It's like it's a contract. You're being contracted to voice a character or an identity for said company. But I think that there is an argument that can be made that since their lawyers are not schooled or have any kind of acclamation of what the laws are in Canada, because they contracted out to a talent in Canada and allowed them to work remotely, they are therefore obligated to honor their countries' laws in addition to their own. You see what I'm saying? Since they allowed her to work in Canada, even if you are a company in Japan, and you allow them to work in Canada remotely, and they're an employee of your company, that they may have an obligation to honor Canadian law in addition to the Japanese law. But that depends on what the bureaucracy of each government has signed into agreement, as well as whatever international legal agreements exist as a whole, as a universal right, in international law, is whether or not those things are spelled out in international law between companies, and that they would honor each other's laws under the labor laws as they're written. So I believe that there are certain criminal laws that are universal between countries, and there doesn't need to be a signed written agreement between countries saying that they would honor those criminal laws. But I don't know whether or not this particular case, or what she's trying to claim, falls in line with those criminal laws, or if that falls into a different category, because they're labor laws in addition to digital information laws, and disclosure of information laws as well. So let's see here. I watched some of Far-Eyed Vid and same kind of video, but I don't 100% believe some of it, but at least I use the info to have a base of the narrative of the story. And CJC, thank you for that comment as well. It's good that you have that, that the information is being brought out and presented, right? However, I would encourage people to not just take what he says, as well as a lot of any other commentator, including myself, at face value with what is being presented. That's why, like, when I try to do talks about this or streams about this, I try to include as many sources that I'm using in my description section, so people can go and fact check me, and make sure I'm not misrepresenting a certain thing. But that being said, I would hope that people I would hope that the amount of people that watch videos like this don't just take it at face value and move on. I know there is, and that's what he banks on. That's why that's why he has 300,000 people that have watched this video, because he banks on the title alone that Mr. Esquire destroyed, quote unquote, destroyed Nijisanji, which he didn't. And what Falside is counting on is that they will look at the legal matters archive of what the clips he is using. Look at that archive and say, I don't want to watch 6 hours of that archive. I just want to know what was said. And so he's banking on that people will just take the clips that he has presented as the entirety of what Legal Matters has said, and you end up keeping that narrative in your brain if you move on and you don't either have the right context of what is being presented, or watch the actual source itself. That's why I talked about about this yesterday for a number of hours, and I think we spent 2 hours or 3 hours on just the first hour of this show, because there is so much here that for any other person, they was like, okay, so I hear a 15-second clip, okay, and then they move on. And what people like False Light are counting on, they're counting on the low information, give me quick info type of people to click on and watch his stream, and then just take it as gospel. And because he presents it that way, he gets people that come back, because people want to consume this information as quickly as possible, and he could basically spin it or slice it or say whatever he wants, because he knows those people are going to come back, and then they're going to start believing him. And if you don't give all the correct info, all the pertinent info, and you don't provide the entire context of the clip itself, you end up having people believe things that are not true. And then you end up exacerbating a situation that is much simpler than what it is, purely because you're trying to get people to watch your video, or try to get, maintain your popularity, or you're trying to, provide the little nuggets for your fan base to follow. I mean, that's basically what it amounts to, and it's wrong. It's sickening, because you are not getting you're not getting the correct context of these clips that he is showing, because he's slicing them to fit his narrative for views. What he's presenting is true and accurate, up to the point where he slices the content or the clip to be able to fill in the blanks and then spin it the way he wants it to sound. And that's exactly why this video is making it sound like everything that was said in that 5-6 hour video is all the little comments that he has sprinkled in here and there. But there's either a lot of misconception on Legal Matters' part, or the perspective he's giving is purely speculation, where he states it's speculation, but False Eye cuts out that part and purely uses what he's speculating on. You just end up having a mess of misinformation that is based on a kernel of truth, but then is spin the way that just misleads the viewer. I feel it's highly unlikely to come to a legal battle given the situation of both company and Doki. If it did come to it, I feel it's more likely to reach out, be settled out of court. Yes. So a few things. A few things that. Thank you. Thank you very much, Mute. Okay, that went a little too slow there. Yes, that's a dad joke. Okay. Anyways, thank you for the comments, though. I thank you very much. I appreciate that, because I believe you're also right with this. I honestly believe, all right, this is my opinion. I honestly believe, based upon all the evidence and everything that I have researched and been able to uncover regarding the specific laws that could be or would be relevant for this situation. And mind you, I'm not an attorney. However, I have worked for over 6 years in information services and IT. That does include maintaining personalized information and handling of personal information in a medical setting. I worked for 6 years for a healthcare facility that is part of the Mayo Clinic network. Okay, so I handle personal and patient information on a daily basis. Based upon what we have right now, and by the way, I also worked 7 years in mental health. So that and I'll tell you why I'm bringing that up in a second. I believe that were this case to go to court, Nijisanji would have enough sufficient evidence to counterclaim and countersuit her for defamation. And because of that, they would likely settle out of court. All right. And that settlement would still have to fall in line with the defamation law, in which they would, they may or may not give monetary compensation. There may or may not be monetary compensation here, especially if Nijisanji in any color countersuit her and say that based on your comments, which are on the internet and are published, they're published comments made by her, and that she has made the inflammatory statements about said company. They would tell her, we have a case, a strong case, and I think her lawyers would also agree to what I'm going to say, that Nijisanji has enough sufficient evidence to countersuit and say that because of her actions and comments, it has cost our company X amount of money and X amount of profit over this time span because of your actions, and we're going to countersuit you and bring that information to court against you. Okay, regardless of whether or not they're in the right or wrong regarding her termination, that would be irrelevant because they would countersuit her for loss of monetary gain, both on their stock value and monetary value for income and revenue, because of her defamation of character of the company. Okay, now I believe that's the way that they would go with this. I believe that they would probably have a strong enough case to say, yeah, we can take her to court on this, and retaliation towards her. And then her lawyer would turn around and say, look, even if you win this case, you're going to lose because they're going to turn around and countersue you. And the best result or the best outcome would be both of them saying, okay, we're not going to seek any monetary damage. However, our actions hopefully have at least brought to light, the situation of employment with your company. And my client will issue an apology if you drop the charges and do not take action against her. I believe that's the way it's going to go, and maybe even it will publicly come out that that's the way it's going to go. I believe that's the way it's going to go because she is not going to make it get or gain anything, whether it be monetary restitution or anything. She's not going to get anything if she wins her case, because the countersuit to that is going to completely invalidate anything that she may gain off of her win. And the best course of action would be, if her lawyers do see that she has a case to stand in court, see whether or not it's airtight enough and that their client no longer makes any public statement regarding any lawsuit that they're pressing forward. Because anything she says, both now and historically online, is admissible in court and that can be used against her. Everything from her self-reporting that she was in the hospital, her self-reporting why she was in the hospital, her self-reporting in the past that she has, or deals with a mental issue. All those things can be used against her, and saying that their client does not abide by said rules and has made this openly public, and because of our concern as her being our talent and knowing that she has these conditions, we try to accommodate her conditions to the best of our ability. They can use that against her because she is volunteering that information online. And that's extremely important when it comes to what type of action or reaction Niji could do. And they may actually leverage that against her so she doesn't sue. And I honestly, I think that Dokibird has, made her point. She has provided, enough insight to state that there does need to be change in Nijisanji En, and that she has already successfully transitioned from her position or from her former talent agency back into an independent VTuber, into an independent self-employed, right? Her current transition and her current situation is 100 times better than what Russia's situation was. All right. And and there was still a lot of things that Russia, Miki and Nico was dealing with that we didn't know about at the time. And she had, Miki with Miki and Nico. Miki and Nico is a great case example of a talent that was a VTuber who also divulged her medical information about having having bipolar disorder, having a depression disorder that by being bipolar, or manic depression. I'm sorry, it's now more formally called manic depression. She openly expressed that, right? And not only did she openly express it, but she had a time period where she had to go on complete hiatus because of said mental condition. Dokibird has not done that. And if anything, Dokibird has been chugging along just fine. She has gone back and turned on monetization on herself on her channel, and she's bringing in revenue for herself within 2 weeks of the termination from Nijisanji. So a case can then be made that from Nijisanji, she has done all this. It's out in the open. It's in the public eye. She has not lost any value. If anything, you can see how popular her channel is, how many people are watching, how many views she's getting. There is no there is no monetary loss on her part. She even admitted, or tried to admit that she never made a profit working for Niji. So now that she's independent, that means, she's saying that she's going to be making more on her own than with that company. She's basically making the case for them that, if anything, they're the victim and she's not. So she has to be extremely careful about what she says in the public, But ultimately, I think this may play out where she makes a public apology. They accept it. No monetary loss or gain happens between each party, and they go the separate ways. That would be the best outcome for the entire thing. And I would if I were her friend and I was sitting there and she was telling me everything that was going on, I would say, look, just apologize for the way that this happened to Any Color and to your fans. Just apologize publicly. Say, I apologize to Any Color and the fans of Nijisanji and the fans that followed me with my employment with that company. I'm ready to move on. This is my apology. Please accept it. I would like to, part ways amicably with them. This is the last that we're going to talk about that. We're going to move on. I'm moving on to bigger and better things. They can move on and they can do, whatever happened, what they want to do with their company. That's it. That's what I would tell her to do, because I don't think she's going to gain anything other than maybe clout. If you consider clout a worthy enough cause to spend the money on a legal case, then okay, whatever. But I don't think that, I would not advise her to do that. See here, Niji was the one to bring forward possible bullies and harassment. Well, according to the statement, Niji, they mentioned that as far as their the termination notice goes. So that is absolutely true. However, I believe because it was in the statement that was given to them. So, it's here. Workflow, unauthorized, result in delays, payments, inappropriate behavior. Let's see. I don't remember what page it was on. Immediate response. Yeah, I believe that they brought forth the idea that that there was something like that going on. However, I believe she also, see, here's the thing, we don't have the document in front of us of what whatever document it was that she sent to Nijisanji with her grievance. So I believe that because it was spelled out in her grievance that was sent through her lawyer to Nijisanji, they felt compelled to address it and react to it. That doesn't make it right or even legal. But again, if she did name people specifically, if she did name people specifically in her grievance, that those people are then implicated into whatever lawsuits she may be filing against Niji. So as a legal attorney, and if they were providing legal advice, they would need to brief, at minimum, they would need to brief the individual regarding the grievance that was sent that implicated them in the statement. And if you've ever been in a situation where you have gone to court, you know that the information, at least on the Western side, your lawyer or your attorney has a duty to to obtain said legal document, and then because that document is evidence, and then you have the right legally to see and know and understand not only what you're being accused of, but you also have the right to review any evidence that is brought forth if you are being implicated in a crime. And that's just the way the legal system is. You have the right to review any legal document that implicates you in a crime, because you are now an actor in said or accused crime that was against another party. So you have the right to be able to not just see the evidence, but also review the evidence with your attorney, whether it's that attorney belongs to the corporation or any color or one that you hire on your own. You have the right to see and review any evidence that is going to be used against you to implicate you in a crime. And that's another thing that is completely missed by Mr. Esquire here, and also by Falsi, because they're basically saying, okay, yep, they, she sent them a legal document, and they show them the legal document. Okay, yep, that's bad. That's not right. You shouldn't be doing that. That's bad. Why not? That stuff is evidence that is being used against not just the company that you're working for, but also you as a person. And they're actually making the defamation comments, against you as a talent that works for said company. If you're going to be charged with it, and you're going to be name dropped as a co-conspirator of said crime, you have the right to review that information and that evidence, so your lawyer can build a case in your defense. That's not, that's not legalese. That's not something that, you have to go to law school for or be an active or licensed attorney. That is a basic human right that, is universal. You have the right to know what you are being charged with and the evidence that they're using against you for said crime. You don't have to be a lawyer to know that. It's common sense. So for Dokibird to have a lawyer-driven document that is presented to any color saying, those particular employees that work for your company have bullied and harassed me, and you guys did absolutely nothing about it, so we're going to take you to court for providing a hostile work environment, or or poor conditions to work in, or whatever the initial charges that they're going to try to use on this situation. For her to name drop them in that document, even though it's a legal document, those attorneys can then turn around and say, because of your actions while representing our company, we are being charged with blank. And they have the right to present those people who are implicated in that document to see the evidence and review the evidence so they can build a response and a defense against said evidence. It doesn't mean that what they did is right. Okay, I'm not saying that they're right. I'm not saying that the people name dropped are right. I'm not saying Doki is wrong. What I am saying is that there is a very big false narrative that that because these people are only employees and that there is personal information in this document, that they breached the information law is not true. And one of the exceptions is if you are if you are being taken to a to court over a specific issue, you can request that personalized information to be presented to you either by subpoena or otherwise for use, in your defense or for your complaint, your criminal complaint. So, I mean, this narrative that A plus B equals C, it may equal C, but then you have to complete the equation. There is more to the equation than just, A to B equals C. You then have to take C and then you have to apply it to another equation because you are implicating other people as co-conspirators of said crime against you. So those parties have the right to be able to review whatever charge is being brought against them. And to be completely honest, and something that Legal Matters completely skims over is the fact that even if they can find something in the law saying that that Nijisanji cannot expose them to that information or hand them that document or whatever, it's been mishandled or whatever, even if that is brought to task in that statement, all right, the only thing that Nijisanji needs to do is then you file for bringing those people in as witnesses for testimony for the case, and that information is going to be presented to them in court. And because they are the lawyers for the company which they work for, all they have to do is file a motion that they are co-defendants in this case, so they are privy to any information that is being presented by Dokibird. It's a PIPEDA violation and potentially a breach of contract to share it as it was. See, and that's just it. Okay. First, it really depends whether or not that law applies internationally and whether or not they can make a court case around it. And remember, and this is what a lot of people just won't accept. As is, in any kind of complaint would first be dropped into a Japanese court where that law may or may not apply. All right. Because Japanese law supersedes any laws that are brought forth from a foreign court. All right. Just like American laws and rights are, they supersede any other laws that are out there. It doesn't mean that you can just arbitrarily break those laws. However, your rights as a person, especially as an American citizen, supersede whatever rights or laws that are in the country that you're in. That, and again, that does not mean that you can go into another country and break their laws. What I am saying is that you have to remember to look at the court system that you're walking into, what the court system is that is being represented in that court system, and then what laws you're trying to apply to yourself and the defendant in that court. If you can walk into that court and take Canadian digital privacy laws in there and be able to argue that those laws do apply in this case, then yes, there is a case for it. However, are you even going to be able to win that case? And even if you win that case, has she already done enough damage, to herself, to where Nijisanji can countersuit her and either win their countersuit or just invalidate the entirety of the legal argument? That there are many ways this can play out, and I mean, if I were to sit here and look at this, I could say, well, they broke HIPAA, they broke HIPAA laws. Okay, so they broke HIPAA laws, but that law only applies to this country. That law does not apply to Japan. And if you say, well, she was an employee that was living in Canada, that may be the case. However, she also pays taxes to Japan because that is her employer. She has to pay taxes also and claim income as a Canadian resident or citizen. She has to file there as well, but she also has to file for income taxes because she works for a Japanese company. All right, I mean, so yeah, in that case, you have one set of laws that are dictating how much is taken out of her paycheck by Japan, and you have another set of laws that applies specifically to her but doesn't apply to Japan. And that law stipulates how much Canada can take from her because she has an income and she's a resident of that country. So, you have to really look and see whether or not one law applies to both systems, or if that law is separated based upon territory and what the code and the law states. I mean, you have to be very careful. Wiley, welcome to the chat. Thank you for dropping in, my friend. I appreciate you being here. How's AFK? Where are now? So we're still. I was at the tail end of watching this part here and discussing it. What does Nijisanji have bad lawyers? The short answer for what you missed is I don't believe they have bad lawyers, because they have shown statistics of what the company has done over the past year of bringing cases to court, which ones have they've taken, what they've done, so on and so forth. And he mentions that there is no poster child for what their lawyers should even be doing in regards to defamation and libel. That's also false, because there are public reports of how many cases they have taken to court for defamation against Nijisanji. So, I mean, the argument he's making is purely out of ignorance, because he does not know and has not looked at the information that's provided publicly. He is only making a speculation of what he perceives based upon what he's being told. Right?
This is their Titanic. They have no precedent for it. Don't
see this entire rant here is completely biased with ignorance of what they've actually done versus what he perceives that they're not doing or perceives are missteps by by the actions the company has done. Also, they bring up the fact whether or not statements or documents or anything of that matter have been reviewed by legal. He makes the claim that he does believe what was said, during that 15-minute, completely blackout video with Vox and Ike and Ellera. He does believe that it was scripted, and that that scripted information was approved by legal beforehand. But he's making the claim that with the termination notice that the lawyers had no idea what they're doing. He feels like it's a complete big misstep, and he does not remember. He does not know, and he's not as intimate in the VTuber and idol culture as is today as what he knows, because the only perception he has of that culture is what's being told to him, and then also his experience with K-pop idol culture. So that he's making assumptions based upon that limited amount of information. All right. And then when you make comments like this, it ends up as sound bites, as what we're seeing right now.
Don't pretend they know what they're doing. They're all panicking just like everybody else.
No, they're not. They are definitely. They may be panicking regarding, what is, what they're going to do, because they're waiting for her to do something, before they react to it. However, I guarantee you that if a case gets put into court, and she announces that she is continuing with the press, charges, and she makes that claim publicly, she will get countersuited for libel and for loss of revenue, because of her actions. And she may win the first battle, the first argument, but she will lose the countersuit because of what she is doing or what she has said. Sorry, I just swallowed water wrong. Sorry about that. That went down the wrong pipe.
Next up, can Dokibird settle?
Right. Donald Gill says it would settle the day they do not want to discover. Yeah, and they would try to. And by the way, I'm sure Doki would want to settle. I'm sure Doki would want to settle and get this done with. Right. Is if it survived a motion to dismiss, I think they would just pay out. It'd be better for the corporation. It'd be smarter.
See, and this is absolute truth. Okay, this is probably the only soundbite that carries any water regarding the fact or whether or not legal matters destroyed Nijisanji. This is probably the only statement so far that carries any water and feels 100% legitimate based upon everything we know. All right.
If I was their corporate attorney, I'd tell them just to pay her.
My guess is what would
happen. I would not. I would absolutely not. I would not tell them to pay her, because they have the enough evidence. Again, he does not know. He is not taking into account the law, the defamation laws in Japan as they stand, the internet slander law that was passed. He's not taking that into account. He's not even considering that. He is purely looking at it from a standpoint of talent is mad, making throwing a fit about it. May have a case, so let's just end it quickly by paying out. All right. And the irony of that situation is this, all right? If you settle out of court in Japan, if you settle out of court, there doesn't need to be a monetary compensation for it. If they sell out of court, all they have to do is say, "Hey, look, we don't want to drag this out. We had a bad break. Let's just go our separate ways. We won't sue you if you don't sue us." All right. All they have to do is then make a public apology. Both of them would have to agree to make a public apology and then go their separate ways. There does not and would not be any monetary value or compensation on the table at any talks that happen between the two parties. It would first be, we'll issue a statement and a public apology. We'll send, we'll wish you best on your future endeavors. If you, apologize for the whole debacle, and all the noise that came out as a result of it. If we both do that, we just walk our separate ways. We don't have to get messy and do this in court, because otherwise they have, legal matters completely and utterly dismisses any credibility or any kind of defense that Nijisanji would have in this case. He, and all these sound bites do actually, sway public opinion that way, because he does not give any indication that Nijisanji, has a defense in this matter. He doesn't even consider it. He is purely giving a perspective based upon the accusations and the prosecution of Doki against Niji, and he does not. And honestly, I think it's not because he's biased. I don't know his deep inner accolades regarding being an attorney, but I bet you anything that he is not a defense attorney. And that's why he is giving a legal perspective as a prosecutor. Because if he was a defense attorney, he would be giving the side of the argument where Doki has a defense, what the defense of Doki would be. He would be talking about the evidence that's out there for her defense. He would be talking about Nijisanji and what kind of defense they would have based on the evidence and the law that as is. But he doesn't do any of that, because it sounds like he is more of a prosecutor or an attorney that does prosecution when it comes to specific lawsuits that are levied against either a person or organization, as opposed to a defense attorney, which would have the mindset of, we're being prosecuted, we're having things happen to us. What is the defense that we have that can not only acquit our prospect, but also prove in court that the company that she was working for was negligent in A, B, C, D, and E. You see what I'm saying? All of his statements are completely dismissive. I think that that part was on part 2, but I didn't hey, you did better than what I've done. I'm still at the tail end of part 1, so and maybe he did get you talk about it in part 2, but I honestly don't think that that False Light has even talked or even tried to touch that subject, because the entire narrative of his video is that Mr. Esquire destroyed Nijisanji and any color with his evaluation of the lawsuit.
What happened is they would try to settle and have both sides issue some sort of public statement like the matter is handled, please, leave
Now,
people.
that is correct. What Gator is saying is correct. That is a kind of a natural. It's not just a standard that people do in the entertainment industry, but to once again be able to tie that to a legal document that is under the civil code of defamation and the law of defamation for Japan, where under the civil code, I'm going to read this again. Under the civil code, defamation constitutes an unlawful act for which monetary compensation and or other suitable measures, such as a public apology for the restoration of one's reputation, is required. So even if and I'm going to make this statement before moving on here. Even if they don't go to court, but they both, one party or the other party issues an apology, this is between us. You can share this if you want, but this is between us. If they do issue another public apology for all the stuff that's happening with Celine and Dokibird and everything else like that, that's pretty much an admission of defamation. Okay, so just keep an eye out there. Okay, if you do see that after today, or from today forward, if you see them issue another apology, that's pretty much an admission of we defamed that person and defamation did occur. So just to put that out there, okay? So let's move on just a little bit.
Alone
with an
probably
NDA.
do something like that.
With
With
an
an
NDA.
NDA, so they can't talk about it.
However, there are concerns for Dokibird.
So, regarding a recording, this was not intended to be anything other than a distribution test for a planning of a collaborative event between two people, which happened to be left over from one test recording. I never recorded any other conversations with anyone. So it wasn't even, she didn't even record it in bad faith. But regardless, it doesn't matter. It's one party consent. So fuck off.
Right. She has the right to do it. So, you
Right.
know.
I've asked my lawyer.
Hold on just 1 second. Okay, sorry about that. So, so basically, let's go back just a little bit here. The document mentioned was first made to a document with my thoughts and history with evidence, so that my lawyer can see the general picture of what's going on, and if there were issues that should be addressed. It was first made during my darkest time mentally, and I wrote everything on my mind a little at a time. Okay, so number one, she has publicly put out this in the public square that she was having mental issues when that document was made. Okay, so let's be clear on that. She had already at this time when this post happened, she had confirmed what was said 4 years ago, that she does suffer from mental issues. Now that doesn't mean that her lawsuit gets thrown out. However, it's something to bear in mind that she disclosed this personal information. All right, this is out there. That was out there for anybody to read. Anybody could see it and talk about it. So if she tries to use the fact that she had a mental episode and that was not supposed to be shared or talked about or whatever with other livers out there, this is in the public square. Anybody can go to it and read it. All right. So you cannot make statements like this in the public square and expect any ounce of confidentiality or private conversations when it comes to that same topic within the company or employer that you're working for. Because if they can go out and read it, then they know about it. it's automatically assumed that since you're publicly disclosing it, that you are it is not bound by confidentiality laws. Okay.
Collaborative event between two people, which happened to be left over from one test recording. I never recorded any other conversations with anyone, so it wasn't even.
Okay, so let's see. I was never. It goes on to say, I made the document thinking that it was never going to go public to anyone but my lawyer. Okay, so she made it in confidence and gave it to her lawyer. All right. Although it was a document filled with my personal information as well, privacy information that should not be made public, there was no other addresses or specific locations mentioned. Okay, so she is basically refuting the claim. All right, now this is a he said, she said moment. She's refuting the claim that the document did not name other livers or their locations or where they live or anything else like that. That is a complete contradiction to what Elora said in her stream between about her and Millie. Okay. So there is a contradiction here. She's making the claim that the document didn't contain that information. Now, that's fine. However, if said document is presented in court and it does contain that information, and they bring up this post and say she claimed one thing, and here's the actual fact because here's a copy of the document is another thing. She's already lying about evidence that is being presented in court. Okay, so this is kind of a slippery slope here because they are just immediately going under the impression, okay, because of this, it didn't happen. What Nijisanji is saying is false. That's basically like the reactions that are being given. You cannot make that kind of reaction when you're listening to this case in a court of law. If those things are in the document and she made the claims publicly that they aren't, she is lying about evidence. That itself can be grounds for like, well, she's lying about evidence. The evidence is there, and she's making false statements about said evidence, or is trying to mislead the public. Again, that goes back to defamation of character, because she's lying about said evidence and calling those liars. All right. And because she's calling them liars, she's defaming Nijisanji, which goes right back into a countersuit. All right. I just want to be extremely clear on that because, it's very easy to just listen to, their narrative here and dismiss that particular portion of it. All right. So, regarding a recording, this was not intended to be anything other than a distribution test for planning of collaborative event against two people, which happened to be left over from one test recording, and I never recorded other conversations with anyone. The recording was never shown anywhere or even in a legal setting, and there are no other records. However, I regret it was mentioned, and I'm sorry to all parties involved that misunderstood this. So this in itself, could be what they're referencing to regarding information that involved those other parties, Elora and Millie and them and things like that. Now, if that digital recording does exist, and that discussion was made in that recording, but it was not in the legal document presented to Nijisanji, then that is grounds for dismissing what Elora and Millie, what those livers, what Elora was talking about regarding information that would expose their private information. but it has to not be included in the legal document or the legal complaint that is being brought forth against Nijisanji. Now, if I was in Legal Mindset's spot, I would immediately see this and then, and then try to make that connection in my mind and say, okay, so basically, what was said, what was true, as an interpretation of of the information that was presented. However, she did not disclose it. So that can be safely dismissed as a concern that information might have gone public. You can dismiss things if you're able to prove that it didn't happen. All right. But at this point, all we have are assumptions that she supposedly had put forth a document that claimed that she, that claims specific things, but she still has not addressed whether or not she had name called or who she name called in that document, saying that they bullied and harassed her. So let's go on.
She didn't even report it in bad faith, but regardless, it doesn't matter. It's one-party consent, so fuck off.
Right, she has the right to do it, so
right. I've asked
now. That may or may not be true. I don't know if Japan has a one-party consent law regarding, recording of conversations. That's something you would have to look at. So for them to say that is completely irresponsible unless they know beyond a shadow of a doubt that there is no, whether or not there is a one-party recording clause in Japan, or whether or not you need to have two-party consent. That is extremely irresponsible for both of them.
It's my lawyer to convey that and communication that the document as it was written wasn't going to be released anywhere. And my lawyer did so when sending the document. Okay, I've got concerns here, guys. I'm going to be honest with you guys. This is me being really fucking honest. I have some concerns about her lawyer. Okay?
Thank you.
Here's my concern. Reading this as a lawyer, right? He could have offered to make a summary. He could have offered to make points. He could have offered to have a version that he could have done that removed a lot of private information that would hurt Doki. He could have protected her better there, I think, as a lawyer, right?
Thank you.
And not knowing that there's a potential for disclosure and not telling her that we can give it to the lawyers. Because look, a job of a lawyer, what I do as a lawyer is I disclose all of the possibilities, okay? I think what he may not have.
And that's what he should have been doing for the first couple hours of the show, which he didn't.
Done here is, number one, told her this could be disclosed because it could, right? And to lie and to pretend that it couldn't. You have to say there's a potential chance.
Thank you. Exactly. This is exactly the entire point. And I don't know how long it took to get to this point. However, he is finally, he's finally telling the other side. This is probably the most truthful part of False Eyes video here. But of course, when you stack the first 8 minutes of said video, with nothing but sensationalized arguments that he destroyed Nijisanji. Let me be completely honest with you guys. Out of the 323,000 views that he got for this video, 9 times out of 10, people don't watch more than 3 minutes to where I'm at right here. Most people they consume maybe 3 to 5 minutes of a video, and then they don't bother listening to the rest of it. And those are in analytics, and that's a proven fact. Any type of video, and that's why they highly suggest that if you're dropping digital content that's just being recorded and uploaded to your channel, they recommend that you either do the shorts or that you do about a 5 to 7 minute video. That way you get past a certain analytic marks for consumption, and then you also get past the certain analytic marks for advertising revenue and so on and so forth. But most people, if you get to the 7-minute mark, congratulations, you've held your audience, with your content. But if 50% might watch past 7 minutes, maybe, if you're lucky, but a lot of times they don't. They just want to know exactly what was being said, and they'll, if you don't capture it, and they even say, if you don't capture your audience within the first 30 seconds to 1 minute of your content that you upload, you're gonna lose them. That's pretty much what they tell you. And if you're able to put your hook in, within that first minute, if they watch up to 3 minutes, congratulations. You've had a successful upload of digital content. But I mean, I can show you my own analytics of things I've uploaded and where the fall off is for viewership.
And beyond that, change the information, alter the information, summarize the information just a little bit better. I'm not saying that he's incompetent. I'm just saying that maybe he could have done better. Okay, that's me being harsh on Doki's order. That's not Doki's fault. Lawyer, right? Lawyer of Doki.
Legal mindset as.
Okay, so let's go back a little bit here. So basically, in this part here, I requested that I just wanted to move on. Sometimes I didn't hear anything for days from the lawyers on the other side, and felt like I'd be alone and isolated for a very long time. It made it so hard for me mentally. On the 5th, my lawyer discussed and said it would be best to show the document I wrote with the other lawyers, as we have not heard from them for a week, or any negotiation talks, given a meeting or to discuss my request to part. So essentially, what she is saying here is that she is claiming that she had conveyed to Any Color on the 5th. Okay. And let's just make this really clear. On the 5th of February, that day, she had requested her termination, her let go, her graduation notice. She requested that she wanted to move on. And Any Color does address that in their posting here. And she requested, okay, let's look at this again. I requested, I just wanted to move on. Sometimes I didn't hear anything from the lawyers for days on the other side, and I'd be alone and isolated for a long time. So it made it very hard for me mentally. On the 5th, my lawyer discussed and said it would be best to show that document to the other lawyers, since he had not heard from them for a week, or negotiation talks were given to me to discuss my request to part. So they essentially took her that document that was sent to them, and they took that and pretty much digested that information as her request to be let go from the agency. So she had made a request to relieve. You're telling your company you want to quit. She's telling the company she wants to quit. All right, so you cannot be outraged when the company says, "Okay, you're let go." You really you can't to make that leap. To make that leap, you have to jump through some very large mental gymnastics to be outraged that they gave you your release. Now, you could be outraged that it went public first, and then you found about later. But again, given the circumstances that she was in, and that she was potentially hospitalized during that time period, and the fact that Niji had, documented that they had tried repeatedly to reach out to her and her emergency contact during that time frame, when the release notice went public. Her reaction to this was likely while under duress. If what she is saying, it makes any kind of timeline of events that's happening here. Well, yeah, and she's making comments, and she's making decisions based while she's under duress. And if you just want to move on, which it looks like she does honestly want to do, you don't press charges against them. You don't take legal action against them. And you basically tell them that it was a disclosing publicly what was going on was basically just her mind brainstorming what her options are, and like legal mindset said, that should have never been shared. Never.
Of Doki.
Legal Mindset estimating that total legal bills for Dokibird, if Nijisanji fights, could go upwards to $500,000. However,
now that is absolutely true, right? And that would not just be fighting that in public. That would also be a countersuit from Nijisanji. That does not include whether or not they fight against her and countersuit her for punitive damages, which could also be upwards of $500,000.
there is a way to make that significantly less expensive to Dokibird.
This case does give a foothold. However, it's regarding an arbitration clause.
What is... Okay, so I don't know if where this case takes place. I don't see... Okay, so the case that he's referring to and referencing here is purely under Canadian law. Okay, this is a Canadian court case that he's referring to. This is not a Japanese court case. So we again have to make the different, there's different laws, different standards, different procedures, so on and so forth. I mean, this is no different than trying to get your digital content uploaded through Niji. You have to look at what the procedures are. Okay, so bear in mind, whatever he is saying here is purely under Canadian law, not Japanese.
Not regarding an employment contract. And
okay, I did cut that off right in the middle. He basically said that this case does not is not involving a employee contract.
This case does give a foothold. However, it's regarding an arbitration clause, not regarding an employment contract and the choice of venue in employment contract. So there's a difference between arbitration and litigation. Arbitration is a different process. It's a different procedure. So
correct.
The courts could distinguish this and say, no, this is a choice of law issue. It's not involving arbitration. It's involving litigation. And where's the litigation area? But at the same time, if they wanted to extend this case, if they want to say, no, we're going to apply this because we're going to look at this case and we're going to look at it and say, Dokibird does not have that much money to go to Japan. She doesn't have the resources to go. She doesn't have the hundreds of thousands of dollars to go to Japan. We might find the provisions that might require her to go there as unconscionable and allow her to bring her case in Canadian court.
Now, this is a matter of dispute because, for her, again, she made the claim that she did not make any money working for Niji, but yet she was able to drop 200,000 Canadian in whether it was commissions or purchasing of digital rights, so on and so forth. You can take that comment that and how much she has claimed to have spent on various projects and say yes, she does have the funds and means. Not only that, but you could look at her analytics over however long it's been since she has started streaming as Dokibird and say, yeah, you're pulling in this much money and you've pulled in this much money over this specific time frame. You have the funds and money to be able to proceed with this court case. So you have to be very careful about this. But again, he's talking about he's talking specifically about a court case that is in Canada and not in Japan.
Or under Canadian labor law.
And Dokibird being Canadian, what potential laws in Canada has Nijisanji broken?
So what is personal information? So let's look at the scope of what personal information is and why they're screwed. Under PAPETA, personal information includes any factual or subjective information, recorded or not, about an identifiable individual. This includes, in any form, age, name. Guys, name. It includes name.
It includes name. All right, and watch the argument that he tries to make here.
So if they have her real name, her doc's name,
Calvin, welcome to the chat.
that would be a violation if she did not willingly give that to them, which she probably did not, of PAPETA. Their Canadian ID number, their income, the amount they make, their ethnic origin. Look at this, blood type. Blood type, guess what they turned over to Nijisanji? Guess what they turned over? Medical records. They turned over her hospital information. Guess what that probably has on it? Blood type. Probably has blood type. So if that was disclosed, there might be some issues there, Niji.
And he has no grounds for what he's claiming here, okay? Because, okay, let's look at his argument here, okay? It says, under PIPEDA, personal information includes any factual or subjective information, recorded or not, about an identifiable individual, okay? This statement alone, based upon what he is saying, this statement alone, Nijisanji has never disclosed any information about Dokibird, the individual. They have only ever referenced Celine, which is an IP that they own. There is a distinction there because the avatar, the name, the likeness, everything is property. It's not an individual. Okay, it's property. That would be like trying to sue Harrison Ford for stealing something while it was portraying Indiana Jones. All right, he doesn't own Indiana Jones. He doesn't own the name. He doesn't own the likeness. All that stuff reverts back to the copyright holder. All right. So if he walked into a place and said, "I'm claiming this because that belongs in the museum," and steals it and walks out, and he says, "I'm Indiana Jones. I'm claiming that artifact because it belongs in a museum," and walks out, he cannot claim that was Indiana Jones that they fired. He cannot claim that was Indiana Jones that stole that artifact. Him as a person is significantly different than the intellectual property that was Celine Sitsky. Okay, so you have to make that distinction, which he is not. Okay, and that goes back, and this again, he's making an argument based upon Canadian law. Okay, now Canadian law, and I haven't looked deeply into this yet, so I won't go as far as what I'm going to say, but when you compare this to Japanese law, Japanese law has a completely different set of rules regarding pseudonymized personal information. Okay, and that is what we're talking about here. Okay, you have to make that distinction between person and character. Pseudonymization of data is defined as in Article 14. This up here is for a different country, right? But pseudonymization is a technique that replaces, removes, or transforms information that identifies an individual. The basic technique for reducing data protection risk. This includes the name and the property of characters for Nijisanji. Okay, there are a lot of different variations of this particular subject depending on what country you're in. However, this is what applies to this case. What he's applying here in the Canadian law sense is he's trying to argue that personal information, age, name, ID number, income, ethnic origin, so on and so forth, opinions, evaluation, social status, he is trying to claim that all this personal information that is defined under Canadian law makes Nijisanji liable for improper handling and release and sharing of personal information, when you have to understand and look and see whether or not this particular definition also applies to pseudonymized personal information that has a completely different set of rules. Because not only are you talking about a pseudonymized, an alternate or an alias identity, but you're also talking about them talking and promoting specific agendas. Where did it go? Oh, did I? Go back. You're also talking about whether or not you're making these assumptions as her the employee or her as the IP. They could legally argue that because again, this pseudonymized personal information applies to Celine, the V-Liver, her as a fictional character that is owned by a company. When she is speaking opinions, evaluations, comments, social status, or disciplinary actions as Celine, that is tied to the character, because that is the only way she is being identified, is by her pseudonym or alias, which is Celine, which is owned by a company that she is voicing and representing. Okay, so when she shares information about herself, which is private information or things that are tied to her real self, if she's doing it as Celine, that becomes part of the character, because that's what is being voiced in opinions, evaluations, comments, social status, and disciplinary actions as that character, which she does not own. So when you make statements on the Celine account for like Twitter or X or whatever social media platform, you're speaking as that alias, not as yourself, because you're representing a character that is owned by a company. And there is a distinction between that, and then when you go onto your Dokibird account and then you disclose information on that account. you're then speaking as Dokibird. If Dokibird represents you and your true self, then that's what it is. But there is a very big distinction between that. And I really don't think in any way, shape, or form that he has an argument here about this entire thing, because he is relying solely on what the PIPEDA says about personalized information and not about pseudonymized personal information or information given under an alias, which has its own set of rules. And if this went to Japanese court, that would be the argument that the Nijisanji lawyers would use, that she was speaking on behalf of a character which is owned by this company, and we have a set of guidelines of the way they're supposed to act. You have an employee guideline book. You have what actions are permissible, which ones are not permissible, so on and so forth. They can then document that she all these rules that she broke and stuff like that. So for he is correct on his assumption with this. However, he's incorrect when it comes to the application of it. Even if this is Canadian law, if there is a completely different section for pseudonymized personal information, he's really barking up the wrong tree here. But didn't Niji give Vox the document? Okay, so my understanding is he made a comment that he handled the document or saw the document, read it in full. I do believe that, but again, there are two things that apply to that are applicable to it. The first one is that if he's being implicated, again, if he's being implicated as what would probably be like a conspirator or a co-defendant in a case where they are being name dropped by name in said document, that said document would legally be evidence in a civil or criminal lawsuit. And they have the right to see the evidence that is being presented against them. Okay, so if she threatened, and we don't know the wording, she has not released the wording of the document that was supposedly circulated. But if she made threats of suing them, of pressing charges, of bringing them to court, and there being potential co-conspirators or co-defendants in a lawsuit, they have the right to not only see what the evidence is against them, but they also have the right to evaluate and provide evidence in their defense. But you have to be able to know what that information is in order to present it in court. And if their client and or their lawyer has not had the opportunity to review said document because you're claiming confidentiality on it, then you can't bring it to court because you're trying to withhold evidence that should be presented to the defense in order for them to see what they're being charged for. And what the accusations are. Now, whether or not it include her record, my understanding was that the document that was handed, that was passed around, only included documentation of a medical condition, which which was conveyed in the document, and then that document was circulated around. Now, if that document was a complete, like, say, dossier or employee record of said person, it would be highly it would be highly objectable, and it would not make any sense for that lawyer to include her entire medical record in said document. The only way that I would see that you would even have your lawyer do that in the first place is if you're blaming that the company for the mental status that she was currently in. I mean, I could see that, but according to that lawyer, that Canadian law applies as long as the employee is Canadian, regardless of where the employer is located. Now that could be the truth. However, if the argument would then be whether or not they would apply Canadian law in Japan, and whether or not they take whether there would also have to be a distinction on whether or not Japanese law supersedes Canadian law in that jurisdiction. Because if you are trying to apply Japanese law and you come along and say, well, my client is Canadian, I mean that's kind of like the same thing where say like you're an American, then you go down to Mexico and you steal a bunch of cars, and then you come back to America and you get arrested in America. You would then have to make the case that because you live and were arrested in America, you want to be tried in an American court, whereas the Mexican court could ask for extradition over to their area purview of where their jurisdiction is, and then so long as you're able to expedite that case, then it would be filed completely under whatever law that country is. So you have to be very careful about when you look at saying, well, this is a universal law, this applies regardless of where you are or what you're at. You're claiming rights and freedom that is specific to your country, and other countries may not honor your those specific rights if it goes against their law, their code of law in that country, and that infraction happened on their soil, so to speak. Well, it's kind of their responsibility to find out about their employees' labor law. Yeah, that is very true. And in fact, well, I would say that their legal team and attorneys should be versed in what the legal code is for where their employees are located. But you also have to remember, a company that is based in a different country and may have satellite employees that are working around the globe. That there is no compulsion. There is no mechanism to tell said company you must learn the laws of Canada because we have employees there. There's no compulsion to, because there are all their assets and all their business focus is in Japan, ultimately in Japan. So there is no, they're not compelled to go learn that those laws because everything is in Japan. The only thing that's over in Canada is an employee, but that employee willingly is working for us that are based in Japan on a work visa. So there are a lot of legalities that are tied together, and it's not just as simple as like what he's saying, where look at this, this is a smoking gun. There's more to it than that. There really is. The saying goes, ignorance of the law isn't a valid defense. Correct. It is not a valid defense. However, again, just because they are ignorant of the law and that is not a defense does not mean that they, technically have to honor said laws in a different country. And it would really depend on whether or not, that you're able to get the courts in Japan to apply Canadian law to this lawsuit. Because I mean, if that's, say, like, that's the this is Canadian law, right? Say, like, they bring this up and they take it to court, and you're walking into the court, and the court, the courts that you're walking into is a Japanese court. You're walking into, they determined that the jurisdiction of said, conflict or complaint, is overseen in a Japanese court of law. That judge isn't versed in Canadian law. The prosecutor, the defendant isn't versed in Japanese law. They could ask for a complete dismissal of the case because they don't, no one has, but the prosecution has an understanding of Canadian law. They could say, well, this is under our jurisdiction. We don't follow that law. We don't know what that law is. So case dismissed. And then she would have to file in Canada and see whether or not the rules to expedite this case from Japan into Canada, because she's a Canadian citizen, has any legality to it. But even if they do, there may not be any mechanism to compel Nijisanji to pay her a settlement or restitution for it. You can make a judgment call on a law, and it prove that you are the victim here, and that they're at fault. But if there's no mechanism to compel Nijisanji to abide by that ruling, it's basically a moot point, because you may have won. You can use that as clout, but trying to get them to pay restitution or if you're seeking damages or whatever the ruling is, that can also be a different story. And that's why it would cost at least like you said, $500,000 in legal fees just trying to get this settled. And again, if she was able to make $200,000 and then drop it on projects over a calendar year, do you really want to pay all that out and then try to get that all back? You know what I'm saying? Is it worth spending that much money just to prove a point? That's what it really starts coming down to. Hey, welcome to the chat. Hey, welcome. Thank you for joining. Let's see here. As the saying goes, internet is bliss. If Nijisanji Legal doesn't now know this, then they have a problem about this. Well, and that's just it. Okay. The other argument that he's making is that you have all this stuff here, and all this stuff is against Nijisanji, and they're panicking and they're wetting their pants and they don't know what to do, and they're probably scrambling. That probably is not even the case, to be honest. I could almost guarantee that that would likely not be the case, because they would know work, they have, again, they have been active. This entire legal team has been active as on defamation lawsuits, defamation acts, other criminal acts that were against talent at Nijisanji. I mean, these people have not been sitting on their laurels like what he said, eating donuts and and not having a clue of how to handle something like this. Their team has been extremely active, as well as cover course teams have been extremely active in defamation lawsuits and everything else. So they might be aware of this, and they might have checked what the legality is of dealing with a Canadian citizen with this entire thing. But I almost guarantee you, since they are again a Japanese company that is employing international people in other countries, they're going to look at this and say, okay, in Japanese law, this is happening, and this is what the path that they're trying to take. Do we have a recourse where we can end this before it starts, and that that first starts going by when they decided to terminate her, when she started making public comments, what kind of defense do we need to have in place to refute these accusations of hers, whether or not we did breach confidentiality laws or PPI laws. There's a whole gambit of things that they would have to test in their with their actions to see whether or not they have the weight to get this dismissed in a court of law, regardless of what the jurisdiction is. And then the burden would be on her to take this to court in a Canadian law and find a court that would take the case and prosecute this case, if you want to spend that much money on it.
You might be violating potato over here.
No, you're not, because they were all talking. The only person they talked about, again, was the intellectual property, the IP, which is a character that is named so-and-so. They've never referenced her specifically.
You guys be careful.
And unless all the all the documentation that was supposedly seen by Vox and passed around and seen by other people, unless that information did contain her entire medical record or anything of the sort, this isn't an argument either. And by the way, all the other people at Nijisanji know her real name, likely know her birth date, or at least have some conscious awareness of what those things are. So, I mean, this is already information that is already known. So, I mean, the claim of information here, I mean, if it even states in her contract, some sort of statement about personal information or exchanging of information while you're working as a second tier party for a character, I mean, this information is going to be public knowledge on some level.
Opinions, evaluations, comments, social status, and disciplinary actions. So
all of these were directed at Celine, the character, not as her, the person. If anything, she disclosed that information publicly, and that information became public knowledge along the way before her termination, by the way. All those things were said publicly before her termination. And then Nijisanji posted her termination notice and validated that information as the reason why she was terminated.
So if she included information about disciplinary actions that she faced, and let's say that she faced discipline from Alira. Let's say Alira was mean to her, but Ike didn't know about that. And Ike got that information. Violation of PAPETA.
No, it's not. No, it's not.
Nijio.
Nope. No, it's not. It's not because, again, the disclosure of information was specifically attributed to Celine, the character. And she was representing said character on all these platforms. And that does not disclose who she is to anybody. And the people that it was disclosed to already know that she is a person behind the character. And also, again, if she implicated anybody else in said document and they become co-defendants under the legal umbrella of any color with those accusations, they have a right to know what the accused is accusing them of. He doesn't even touch that.
Employee files.
This also, all the stuff that he's talking about here also does not apply to intellectual properties, which the argument would be based on. That all the communication, all the information, all the things attributed, including disciplinary action, would be against a pseudonym, aka alias, of a character that they own.
Credit records, loan records, medical records.
Okay.
Medical records specify the minimum level of all the intentions to create her products, to pay her suppliers. This is all PAPETA stuff. PAPETA does not specify the minimum level of connection that a company must have with Canada in order to be subject to its provisions. Let me read that again. PAPETA does not have a minimum connection with Canada. There's no requirement of a minimum connection. There's no language.
Okay, so the argument that he's making here is with respect to international entities, PAPETA does not specify a minimum level of connection that a company must have with Canada in order to be subject to its provisions. Okay, now this basically means that, you know, if you're an international company and you have employees in Canada, they don't have a minimum requirement. All right. But that does not mean that the law can be applied in a Japanese court. You know, therefore, it is likely that a foreign company operating only marginally in Canada, for example, by hosting a website, is available to Canadian entities, etc., will be subject to PAPETA. Now, it does not specify, again, it does not specify that they are required. Okay? She can make a case stating that because I live in Canada and this information was, you know, circulated or seen by people outside of HR or, you know, public relations or, you know, whatever, you know, in the management circles, you know, she could try to make a case stating, you know, they broke PAPETA laws. PAPETA does not have a minimum level of connection that a company must have with Canada for me to claim this. This is what happened. However, the wording specifically is, it is likely, is not required. It's likely. And she would have to make the case again, the burden of proof would have to be on her end to show the courts that this was something that happened. This is something that negatively affected me. And she would have to be able to tie that into like defamation of character or something else like that. There would have to be supporting points of interest in order for that to apply, because it's not required. It's not required. They have no requirement. They have, this sentence here that he's hanging this entire argument on. The way it's worded, the company is likely subject for it. It doesn't say that they are required. It doesn't even state that they must protect that information. It just says that it's likely. It's up to interpretation. Completely up to interpretation. All right.
Which limits its application to business with a physical presence in Canada, nor are its provisions explicitly limited to personal information collection, use, or distribution solely occurring within Canada.
Also, again, not to be a dead horse or anything, we're talking about a pseudonym, a pseudonymized identification of information. We're not talking about her, unless the document specifically, named her as, in, a practical sense as the identity behind the character. It is always referring back to Celine, the VTuber, or VLiver, the inner IP. And it's not referring to her as a person, whoever Dokibird is. I don't know what Dokibird's real name is. I don't know how old she is. I barely know, some of her medical history, or mental history, based solely on, comments that she has made. But I mean, this information isn't actually out there. The only information that is actually out there that we know of is under her pseudonym. That this law does not apply to under the provisions that he's sharing here.
Furthermore, the act of
Okay. And now returning to that question of which jurisdiction would this court battle take place, we have this.
Japan does not have the privacy law. They don't have a claim. And if a jurisdiction does not have a claim, like they don't have that cause of action, the only venue.
Okay, see, this shows exactly how ignorant he is of the laws in Japan. Okay, her contract presumably governed under JP law. How would she bring or enforce Canadian judgment to Nijisanji? Okay, so she would not be able to apply that law in a Japanese court of law. Okay, but we do know, based upon, again, the act of on the protection of personal information, that is it's a partially enforced law in Japan, does have stipulations for pseudonymized personal information, as well as a complaint process for handling of personal information. Okay. So, and even in Article 40, number 1, a business handling personal information must endeavor to process complaints about the handling of personal information appropriately and properly. The business handling personal information must endeavor to establish the necessary systems to achieve the purpose referred in the preceding paragraph. Right, and then it goes on about what the company's obligations are of handling said information. But this specifically, these sections here, from here down, Article 40 down, are what are applicable towards this situation. Okay, now he's claiming that there is no mechanism in Canadian law, that links up with Japanese law, where she would be able to enforce a Canadian judgment on Niji. That's exactly what I've been saying. Even if she wins a court case in Canada, there is no, like he said, mechanism, and they are not required to enforce said ruling. So it would have to be in a Japanese court of law.
Is Canada. The only venue for the privacy claim is Canada.
Exactly.
They don't have that claim in Japan.
Yes, they do. And again, he is completely ignorant of the law. And actually, I did email him, by the way, and I'm going to email him this link after we're done talking, because he is completely ignorant of the law and said statutes within said law. And since he doesn't want to respond to me on with my initial email, I'm going to send him a follow-up on this later. But
now Japan, Canada, and every civilized country that isn't running on sticks and rocks, right, has breach of contract. Every country that has electricity and isn't in the middle of a civil war has breach of contract claims. You can bring that in any country. But when you're getting down to specific stuff like that, that's a cause of action that has to go in Canada. Now, vice versa, if you're bringing a IP infringement for moral rights under Japanese copyright law or Japanese defamation law that's unique to Japan, you'd have to bring that in Japan. That's
exactly what we're dealing with here. And he nails it right here in this one bit that is buried 14 minutes into this video. That this is an IP that is in Japan that you are claiming that you were defamed on, but the company only addressed the situation by the name of the IP, which they own.
Unique jurisdiction for that.
And just very quickly on the subject of graduations and their legality.
Does graduation notice fall under PIPA? No. I think that's something that they would mutually agree upon. If it's information you agree to release, that's not PIPEDA, right? So if it's something that you both agree to release because you're graduating, that's not PIPEDA.
And that was not all.
And also, the fact that she had threatened specific actions, you can unilaterally terminate somebody without prior notice. I believe, according to what I've seen so far in Japanese law. Okay, so I'm not going to finish the rest of this video because I've already been streaming for what? Good Lord, I've been streaming for 4 hours and we've only gotten halfway through this. So unless I make an 8-hour video, which I'm not gonna do. But just to reiterate here, 14 minutes of misleading content here. 14 minutes of misleading content. Of that 14 minutes, maybe a minute of that content has some weight and reality and can stand on its own. However, Falside really did a disservice to a lot of people by spending this purely to get views and likes and recognition of covering this event. And a lot of what he has talked about and a lot of these clips that he's been that he shared in this video are simply clips which without context can sound any which way he wants to spin it, and that's why he spent it the way he spent it. If you're gonna look at what the probability and what it can be taken as reality in this case, you have to go back and look at, number one, all of the sections and articles regarding pseudonymized personal information, what the obligations are of that company and whether or not they broke those obligations while handling said content or said information. And you have to see what the protections are for using a pseudonym in the public space. Because if you're using a pseudonym in the public space, you are hiding your real identity. That in itself is hiding your identity. You are not portraying yourself. You're by name, you are not portraying yourself. You're portraying a completely different character. So, again, all the stuff that happened, she was in character. All of the disciplinary action was, as a result of her by name and character, not as her as a person. Now, the contract itself may be signed under her name, but that contract might also have the stipulation of that they can unilaterally terminate her due to the disciplinary actions and the amount of violations that she had. And if that's if it's perfectly legal under Japanese labor law, there can't be a problem, because the only problem is feelings were hurt. So we have to be very careful about how we go about approaching this, because you have to look at what the business handling laws are for handling sensitive information, the pseudonymized personal information laws, and how what they encompass and what rights do you get, what rights are retained at while you're using an alias. You have to also look at all the content, all of the actions that Dokibird has done against Nijisanji in any color, and look and see whether or not they can make a defamation of contract or of company against Dokibird with all the things that she has said. Okay, you have to look at it, and if she brought other people into that scope, they're co-defendants. They have the right to know what the information is that is being used against you in a court of law. I mean, that in itself is a universal thing. Whether or not the civilization is using sticks and rocks or in all the other things that he listed. You have a right to know who your accuser is, and you have a right to know what they're accusing you of in a court of law. Plain and simple. Especially if this is trying to track in a criminal complaint. Even in a civil complaint, you still have those certain rights of knowing who your accuser is and what you're being accused of. I mean, that is a universal right as you as a person. And if they withhold all that information and they do summary judgment of you, every country that does summary judgment of prisoners or the accused is condemned by the modern world. So you cannot realistically have a summary judgment of this without those people, if they were listed by name in that complaint, because they have the ability to, they have the right and the ability to defend themselves in a court where that complaint is being brought up. All right. Let's get back to the comments here. Let's see. There is a place doesn't even want recognized international law. That's why they. Yeah. Okay. So CJC, you are absolutely correct on that. See, and that's just it. Okay. And it happens. I mean, unfortunately, it does happen all the time, and we do see that on a more on a consistent basis where and that's where all this stuff eventually goes into litigation and is eventually dropped, or is settled out of court, because if this goes into litigation and the litigation is tied up in international law, and Nijisanji takes that to the Japanese court and says, hey, these are our laws, those are their laws, we wanted to dispute that because we're a Japanese company. They could fight that on the reverse terms, and at the end of the day, you have to really look at this and say, okay, what are we going to get out of this, and whether or not it's worth it. Okay, and I'm not saying that it's not worth it. I'm not saying that. Okay, but what I am saying is, if I were Dokibird and I was in this situation, I would look at this and say, okay, if I'm going to spend $500,000 in court fees fighting this in court, am I going to make enough profit or capital off of what I'm doing now to be able to afford that, or should I take that $500,000 and do something else with that, which I can actually enjoy? For crying out loud, the girl, made an attempt on her life, for one thing. Number two, that's an obvious sign of depression or some other kind of mental illness. I mean, you should be more concerned about your mental health and spending that money on therapy, psychologists, doing something constructive for yourself, rather than chasing this down a legal rabbit hole. I mean, if you think about it rationally, which a lot of people aren't, you really have to ask yourself, is this worth it? I mean, I may or may not be able to bring Niji down because of what they did to me. But is it worth it? I mean, what once you conquer that hill and you've spent all that money, what is the reward for what you're doing here? Internet clout? These are questions you really have to ask yourself as a person. What am I going to get out of this? If I were in her shoes, okay? If I were in her shoes and I had $500,000 in the bank, and I had to choose, okay, press charges against this company or use this money for myself, I can think of at least 500,000 things I can spend that money on. You know what I'm saying? I mean, it's simple cause and effect. I mean, if I had 500 grand, I mean, I would use that to, I mean, heck, I go buy a new car, buy a new wardrobe. Oh, I still have, 450,000 after doing all that. Okay, well, let's see here. I can pay off all my bills with 500,000. So, okay, but that knocks it down. I still have 400,000, or whatever. Okay, well, let's see here. I can go take a nice little vacation. Go see the world now that we don't have lockdowns. Okay, I've done that. I've traveled around the world. I still have 300,000 left over. I mean, I could make an entire year's worth of stuff that I could do with that much money and still have money left over at the end of the year. I mean, seriously. You know what I'm saying? So, I mean, that's my bottom line with this whole thing. I mean, yeah, it's an argument that you may never win. Does that really matter? I mean, really? I mean, it's gonna matter to a bunch of stans and VTuber haters out there and 4chan and everything else. It's gonna matter to them. They're gonna pat themselves on the back. But is that worth it? Are you doing this to please them? 5 minutes later, they're not even going to be paying attention to you because they're going to be on, whatever is next on their radar. Is that worth $500,000? these questions don't get asked, and you have people that are simply, trying to sensationalize this entire situation. And then you have, a legal expert here who, consistently applies Western law to a Japanese subject and Japanese situation, and then he makes statements that, that show that he's completely ignorant of said law. And I mean, for him, that's fine. I mean, he can do what he wants with this channel. Okay. But when you're making misleading statements like that, because you do not know the information, and then you have somebody who clips you and then takes that as gospel and then puts it on his channel and then spreads that around to 300,000 people. I mean, like I said earlier, those people are gonna, look at the first 3 minutes of it and then click off. Is that really worth it? Getting your message all the way down to, the people that talk about you. I mean, what does that accomplish? Nothing's happening. You're not getting anything, substantial or sustaining out of this. Is it really worth the money? If you have it, is it really worth the money? And if you don't have it, is it worth the risk of trying to get this done without having the money? Let's see here. I don't think Doki will have a problem with legal fees if she really wants. The dragons are more than happy to pay legal fees. Yeah, and that's another thing too. See, here's the thing. Okay, say that they do pay for her legal fees, right? And they donate all that money, and she takes this to court. I mean, again, Niji and any color can countersuit her, stating that they have documentation that is published on her live streams and the archives, and also public analytics can prove that she is making a monetary monetary oh, my mind just went blank. She has been able to monetize herself, and she's making a profit. She's making a monetized profit off of defaming their company. And they can go on public analytics and get that information. They can, if she were to fundraise for the legal fees, they can state, look, she is making a profit, she is making a surplus, she is making money off of defaming us because she wants to file a lawsuit against us. And then they can point to all the stuff that has happened where she badmouthed the company. All right. So I mean, I don't want to burst anyone's bubble. However, I'm just seeing how it is. And if that was, if I were on their legal team and I saw that, I would immediately say, okay, the moment she presses charges, we're countersuing her because she's making all this money and she's bringing us down. Our stock prices are down. Our investors are nervous. We have, we have noticeable decreases in traffic and in monetary, value that's coming in from our livers. Some of our livers can't even stream because they're suffering from this. They're under duress from this. They could put all of that into a lawsuit and countersuit her. And I don't mean to be a downer. I'm just telling you what I, if I saw that happening and I was on their legal team, I would be starting there in our defense and counter lawsuit. IRC legal matters also comment how Doki legal team shouldn't pursue this because of her mental illness. Yes, exactly. And that is purely and let me be clear on this, okay? Where I'm not using her mental illness as an excuse or that I'm holding it against her. Because if she has borderline personality disorder and manic depression or even clinical depression, okay, I can relate to that because I have those diagnoses of PTSD, persistent mental disorder, and I forgot what the other one is. I can't think of it. It's mental disorder, PDD, and then MDD, something like that. MDD, because it's major depressive disorder. Okay, I have all those diagnoses, and I publicly disclosed that those diagnoses, before, to the people that listen and my regulars. Okay, so I can understand or at least relate to where she might be in state of mind. And honestly, if she were to pursue this legally, it would be such a mental strain on her because of all the anticipation and waiting and refiling of different things, perhaps even having to show up in court, so on and so forth. It would be such a mental strain on her that I as advising her even from a legal perspective, I would say we got to think about your health first. If you can't pull yourself together, because of what's happening now, or you can't pull yourself to, you just working for the company, what this situation happened because of a situation that was not a huge deal, to be honest. It would be in your best interest not to pursue this. Spend that money on yourself. Spend that money on taking care of your mental health. Spend that money on getting the treatment that you need to manage this situation and manage your diagnoses. Spend the money there. Don't spend it on chasing this. And if I were her friend, I would say that too. Okay, if I knew her personally, I would tell her. I would say, Doki, look, I've looked at all this stuff. I think you have a lot of things that you've claimed on your behalf that are very valid points that need to be directed towards Any Color and Niji, because you clearly have an understanding of the failures within the project and branch group of Nijisanji En. Those are all extremely validating, incredible points that you are making. However, if you're going to pursue this legally, I would be extremely worried about your overall health and your mental stability in the long term, because it's not going to be solved in a month or 2 months. It's likely going to take 6-8 months, especially if you're trying to apply multiple jurisdictions in a court of law. This stuff is going to take time, and you're going to be anticipating stuff. You're going to be having to submit and resubmit and then change and alter and add context and then resubmit it again, and maybe have to fly to Japan and then fly back and then show up in Alberta and then fly back, or Calgary, or whatever province she lives in. You're gonna have all this stuff, and that doesn't include you wanting to keep yourself paid by being a VTuber, and then you have all that stuff. Do you really want to go through all that? You basically told them, if we can't negotiate, I want to terminate this contract. They've terminated the contract. You didn't leave under the best of circumstances, but it's done. You really should just put this behind you And if you're making that much money to be able to afford legal fees to do this, I think you're making enough to be able to do what you want with that money and be more productive with it. That's what I would tell her. It didn't include that clip that LM also commented how okay, so we read that. They didn't include the first clip of when he said that. Yes, they did not. Going by that, Marko is perfectly suited to work for in a black company, as he isn't going to pursue legal action. Yeah. Look, I know you're joking with that, and I've always said, okay, I've always said, if I were to come into enough money, like if I won the lottery or something like that, if I came into, if I came into money, I would want to try to establish my own VTuber group or agency or however I would end up designing it, and I would, go get the office space, have places for you to stream, set up a 3D thing for the VTuber, so on and so forth. If I had that kind of money, because there are a lot of things within the culture of VTubers. I've said this over and time again. There are things within the culture that I do not agree with. Okay, there are practices that that are in the VTuber and idol culture that I honestly don't think have been tested in a court of law. These things happen. Those things continue to happen. And then people start saying, well, that's just the way it is. That's the way it's supposed to work. And then it becomes ingrained in the culture. And then it just becomes accepted by, the greater population. I honestly do think that there are unwritten rules and laws within the industry that need to change. And I also believe that, it would be viable to have an agency where, you handpick, like 4 people, just 4 people to start with or something, where you thoroughly investigate or interview them to find out whether or not they have the qualities, both mentally and physically, to be able to handle the concept of being a entertainer that is using an IP that does not belong to you, but you are going to voice that IP, and you're going to represent my company as a character within my company. And that's the way it's treated. That's the way that Covercore treats their idols or their VTubers. That's the way they treat them, and that's the way that most VTuber companies work. Now there is a thing to be said where, like, if I were to have my own company and then a person comes in and then they say that they want to work for me, and then say like 3-4 years go by, then they want to graduate, right? But they still want to keep streaming. I would honestly, I would then ask them what, and make a stipulation within my contract, or even produce a new contract stating that that person is graduating from my agency, but they're allowed to retain the identity of said person since they are separating from my company. Because I really feel like if a person is, going to find success with something like that, and you can reach an agreement where that person can graduate and retain their identity if they want to, say like there's a monetary sum that, gets, that, transaction between myself and that VTuber. All right. And they pay me like 10 grand in order to retain all rights to, the name, the look and identity of that VTuber. Right. and I'm just using 10 grand as an example. Okay, they pay me 10 grand, I give them the rights. I think that would foster a better culture overall in the long run versus all this kind of secrecy and this whole you are Celine, but you're not Celine because we own Celine, but yet you voiced her. So but yet if you say something that we don't like, we can claim that you violated our rules and you're defaming our company by using our assets to make disparaging comments. There are arguments to be made with all that. Where if it's built into the contract that you come work for this company, you're given a specific model or identity or whatever, and you stipulate, you will have after 5 years of working for me, we will then offer you the ability to retain your name, your look, and any assets involved with said character if you ever choose to leave our company, for a monetary sum, of course. I think that is a very viable way of working things, because then if you have an incident like the Rusia incident, I mean, you're going to erase her off the internet, right? You literally take the time and effort to try to completely erase her existence, right? Just give it to her. Make a contract obligation. If she defames that character and you're going to cut ties with it completely and you're going to try to scrub the internet from her, it's, I mean, if that person is going to be tainted for the rest of their life like you expect them to, why not just give them the character, give them the rights to the character, I mean, yeah, there's a certain ideology behind it. However, I also think that, because of the Western mindset that I have, how I would build my, VTuber metaverse, it would be drastically different than how it is outside, But I also honestly believe that you do need to take the input from the talent in consideration, because they are the ones that that are spending hours upon hours interacting with other people and entertaining and doing all these things. So if there are problems with the workflow or with the way things are handled, I would want, as an owner, to be comfortable enough with my talent for them to walk up to me and say, Marko, we need to talk about this because this is what's happening. And then I can take what they're saying, go to the person that's supposedly managing them and say, look, I was just told that this workflow is not working, and ideally for the way I want things. I'm asking you to make sure that your talent gets things out on time, make sure that they're assigned deadlines and meet their deadlines, and follow up with them when those deadlines are passed. Are you doing that? If you're not doing it, why aren't you doing it? Okay, you have material you need to review and ensure that we have all the correct licenses and permissions to use said content. Where are you on that? Why are you backed up on that? You have to be able to get down in the trenches and say, this stuff is happening. This stuff is costing me money as an owner, right? Because this stuff is not going out on time. Our talent is upset, which affects their work, which affects my bottom line. What is going on? All right. You need to be able to walk up to your manager and your team and ask them that question. And it's not because you're belittling them. It's because you need to know what's going on, because then once that's out in the open and you're able to talk about this among your managers and your talent and the CEO or whatever, you're able to say, okay, how can we do this better so you're not backed up? Do you need me to hire another person? Is that what it is? Do I need to hire a person that manages content distribution specifically to validate and make sure all that content we have the approval for all of that content. You need to be able to ask questions like that. And if you don't have the ability to ask questions like this, and as the adage goes, the inmates are running the prison, and in this case, the livers are running Nijisanji En. If that is the case, then you have to look at that part of the project, which that's what they are, and say, okay, we're not managing this branch correctly, or it's not optimal. What is the hell is going on with this branch, and how do we fix it? Because again, that branch is costing us money. Now, we have already looked into this, and I have displayed many times that this is the Hololive one, that Nijisanji has they are their main moneymaker, that 80 some odd percent of their income in revenue comes from the JP branch, and the EN branch only account for between 14 to 19% of what their revenue is that's coming in. So the JP branch is working just fine, and again, like I've mentioned before, were you to cut everyone in EN loose and dissolve that branch in its entirety, chances are the amount of revenue, or the amount of cost that it gets absorbed by Nijisanji would likely balance out against the amount that they would save by not having that branch in existence. You see what I'm saying? So, I mean, they might end up saving money in the long run, because, you're not paying, the 33 talent that are in the EN branch. You're not paying them because we dissolved that branch. I mean, you're saving costs on salary and all the other stuff that's involved in it. So, I mean, even then, so I mean, and this goes back to what people are trying to kind of pursue and flag wave for. You want to be able to damage Niji. People are trying to throw that as as a war cry. But in the long run, if you actually make them fold their EN branch, they're likely going to make or save just as much money as they make for that branch the way it currently is. He is live now with Nijisanji Defense Force. It feels like VOC voice only bully, but he can't use it in cons because yeah, exactly. And that kind of like goes into the thing about like how for a while certain Marvel characters could not be drawn at Comic-Cons and stuff, because even though and even the voice actors could not comment on specific things with their portrayal as certain Marvel characters because of all the rights issues and stuff like that. Closing EN branch might not affect them according to their projections, but considering the trust of investors, that would be the other thing too, is the trust of investors. If they were to cut loose that many people all at once, that would likely spook the investors and make their stock plummet. So that wouldn't be a wise move, and I think that's why they're trying to take a proactive approach of addressing those things as basically as slander against the company, so they have a law to fall back on, so they can try to fight that with all the slander and all the toxic behavior that's happening behind the scenes, or happening on the other side of the screen with people that are attacking them. I do not want to drop into his chat while I'm live and he's live. And honestly, I am not. I'm not going to give him. I don't want to give him money just to ask a question. I mean, I could, but I don't want to do that, because I want to be able to actually send him a message that includes the Japanese translation, law translation, and the law of defamation when I send a message to him. So, and if he replies, he replies. If he doesn't and he blows me off, well, tough luck. I'll just sit here and comment on the things that he's talking about when and then give my own opinion, as opposed to us actually having a conversation and talking about this, which would actually be more productive, because again, he's making a lot of assumptions purely on guesswork and what he knows as a lawyer, in general, but he's not making correct statements when it comes to what is actually being addressed on his stream. So we'll see what it is. Much like firing Celine might not affect them. Yeah, well, and that statement, that statement was, I think, was made in a passive aggressive behavior, because their stock did plummet while this was unfolding, but it has since started recovering. So I think what the message was to the shareholders is, the stock went down because of loss of confidence, because of us letting go of talent, but we're going to rebound, and our revenue is going to be just fine. It's going to be within projections or whatever. So I think that was kind of the message they were trying to do. But the CEO is saying it's not negligible, but maybe they didn't take into account how shareholders and investors crumbling their trust on them. Yeah, well, and I think that's part of what they're thinking about as well, because we talked about before this whole thing went public that Nijisanji was actually buying back their own shares because their stock value, their value in as a company in itself was either in a stagnant state or it was declining. So, what companies typically do is they buy back their public shares that they have on offer. So there is something holding those shares, and it just so happens that they're reinvesting in themselves as a company by buying their share to shore up the look that their company still has value at a certain price that they're looking at. And then, based upon confidence within that stock, then they can release those shares that they've bought to people who want to buy those shares. So it's like artificially inflating your value price of your stock, and with the idea that you're going to be able to make a profit later by selling that stock because it's at a higher value and people want to buy it. So that's kind of what they were doing. So there was already a lot of uncertainty within their company itself, because they've had to do that twice now within 1 quarter, which means that they were pretty undervalued stock wise, and not a lot of people were buying into them. And a large part of that is because, on the flip side, you have Cover Corporation that does not have this steady stream of talent leaving, and you're not having a steady stream of controversy that has plagued the company for almost a year now. That where it goes from one controversy to another to another to another, and you have this stuff playing out. People who want to invest in this kind of entertainment company or media company or this type of technology, they look at the two and say, well, Covercore is more stable, their stock is cheaper, and their stock continues to climb regardless of what's happening with Niji. So they take the lower bet so they can make a profit off of what is essentially a very hot public stock that has continued to increase in price over the last year. And their stock has only gone up. It has not, it's waved and gone down in some dips in some areas. However, their stock as a whole, on the physical year, has done nothing but increase. So, that's something to be said about that. To be fair, buying back your own stock is a common practice. Yes, it is a common practice, and we don't want to discount the fact that it happens all the time. It happens with other companies as well. It's not just any color that is doing it. There is a reason behind it. It is the point that and the reason, the typical reason why a company does buy back their stock is because either their stock value is underpriced and they're trying to raise that stock value, and they're also trying to show the current shareholders or any potential shareholders that they have enough confidence in themselves to be vested into their own company and take the money that they're making and reinvest it in their company, because they have the trust and belief that their company is going to remain strong in the field or in the the product that they're doing, and that helps raise the confidence and the value of their stock. So, but yes, it is a common practice. It happens all the time. However, those things are indicators that typically signal to investors, this stock may be a little soft. It may be undervalued. And they're buying back their own stock, which perhaps we should wait till it bottoms out, then invest into it at its lowest price. That way, you have no way but up, or you see that happening, and then you wait for their quarterly report, and then you can see what they're reporting on a quarterly level, and if they're continuing to make a revenue and a surplus within their revenue after their operating costs, and then all the other costs involved with the company, then it might be a good bet that while their stock has been soft, if you invest now while they're buying back their stock, it's going to go up. So you're basically hedging the price of that stock, knowing that they're buying back their stock to inflate the price. Then you're if you buy that stock at the price that they paid for, and it goes up, that's profit. So you're basically hedging your bets, but at the same time, it's also an indicator that the company value is currently soft, and that they're trying to increase confidence in their own product. That's another good point. Now in Japan, they have government owned stock. And then they have the privately held stock by the corporate stock, and then of course you have the IPO that's out there, and there is a certain amount that, like you said, they're vested in the company, and that typically those shares within the company are typically held by people who were invested in the company prior to it going public. Those things get converted over to shares. But there's a completely different pool that stocks go into when you're buying back your own stock. And if you buy it back through like government loans or government lending, that goes into a specific pool, or if you buy it back with your own revenue, that goes into a specific pool. It really depends on what the disclosure says about those stocks that are being bought back by the company. And label to be fair, buying back they do it all the time, and being labeled by overseas fans and haters as black company affects their rep. Yeah. This situation and people making the comments about them being black company. I mean, if they are anywhere in Japanese jurisdiction, they typically what they do, and they itemize their procedure in one of these presentations. At least this is what CoverCore does. If you have something that's considered libel and defamation of character or defamation of name by for the company or towards the company rather, they can immediately request from X or Meta or any of the other parent companies of the social media accounts the information of that person, because they're gonna pursue libel against that person. They can request that information from the company, including up to and including the IP address and name and location of said person, and that's all private information, and again, but there's already a legal precedent stating that a company has the right to pursue legal action against that person if they have proof of libel against them. So this whole thing goes around in a circle, and it basically depends where you want that circle to end, and where exactly do you end it for yourself too. I gotta go now. Yeah, Calvin, thank you for dropping in. I appreciate it. I'm also going to wrap things up right now too, because my throat is getting real dry talking about this thing, and I think I've covered everything that I wanted to cover in regards to what our friend over at Fallside did. I mean, things like that are just completely annoying for me, because I mean, here, I'm gonna use the proverbial meme. I'm just a guy here on my computer, using the internet, and I can go into Google and find exactly what where in the code for Japanese law these things are, and people like like him, and and even our friend Mr. Esquire, he doesn't seem it seems like he's only going by the things that he knows, and he doesn't look up or research or even try to find the correct information at times of the things that he's arguing for or against. And that's very misleading towards the listener or the viewer or anything else, especially if you can physically present this information as a guy that's just on his computer at home. I mean, yes, I don't know law, okay? I don't pretend to be an expert on law, but at the same time, I'm able to read and comprehend enough to understand what a sentence says. And even if it's a run-on sentence that's in a code of law, I still have the comprehension skills, which a lot of people don't, to be able to read something within law and then understand the sentence that I read that is enforcing the law, or that is law, or you're obligated to follow those types of things. It makes for a better argument if you actually reference the law that you are claiming something is for or against by having it present and understood. So that, that's my take on it, though. I mean, like I said, what am I? I'm just a guy on a computer, that is a VTuber, trying to explain why people are misleading other people about a situation that involves VTubers. I mean, that's basically what I am. So, anyways, I am going to go have breakfast and catch a couple other streams. I may or may not come back and revisit this topic because, quite frankly, there's a lot of stuff that is being said out there, and by this time, most people have formulated an opinion that they're sticking with, and nothing's going to change that opinion. You know what I'm saying? So, unless new information comes to light, I don't think I'm going to cover this further on my channel, purely because, I mean, I can spend hours upon hours picking apart every single thing that, legal means, or, Mr. Esquire says on his stream, where he just does not know or understand what he's trying to talk about in, a Japanese court of law, and how those things are applicable to Japanese law. I mean, what can you do? I could sit here and make, tens of hundreds of hours, talking it to death, but people are going to already have their minds made up by then. So I'm going to spend the rest of today trying to fix my other computer so I can stream and go back to having fun, as opposed to talking about legal things. And trying to explain what the difference between an IP and a pseudonym and a pseudonymized personal information, that piece of information that encompasses Celine, and then her as an actual person. It does get tiresome. So, anyways, I do want to thank the listeners that are here, and that have come in, and the people that have been here since the beginning, the people that came in, the lurkers. I want to thank you guys for coming in. They're going to be an end of the tunnel for this. Yeah, I do want to say this. I want to, there's going to be an end of the tunnel light with this, and I just kind of want to get there a little bit sooner than the rest of everyone, because you can talk this thing to death and not change people's minds, or you can present the information or the supposed, the claims of correct information online, and then show where they are wrong with said information, and then present the correct information that should have been said in the first place. And I mean, I can keep doing it, but I mean, I would feel like I'm wasting my time doing it, So, the Cool 2T, thank you for dropping in. Beavers, thank you for dropping in. Calvin, thank you for dropping in. CJC, thank you for talking and coming in and being part of the chat. I really appreciate that. The Shadow Master, I didn't see you sneak in, but thank you for being here. I do appreciate everyone that comes in. Gwenwill, thank you for dropping into the chat. Umria 1324, thank you for being part of the chat and being here. I also want to thank all the lurkers that have come in. They're very much mute. I do appreciate your earlier comments. Thank you so much for being here, providing a different perspective for all the listeners that are in chat and the lurkers. Zetsu, thank you for dropping in and being part of the chat. Anybody that I missed? Mr. Haswell, thank you for dropping in. You are the very first commenter of my stream. Thank you for being here. And of course, all the lurkers that are here, thank you so much for being here. I do appreciate that. Everyone that does lurk in my streams, you do help me inch a little bit closer to the minimum requirement for being monetized. If that is not my ultimate goal, I'm here to share my love of the VTuber world and video games and entertainment in general with people. However, I do spend a lot of time also addressing serious topics and trying to present a comprehensive and an average guy, take on things. I do dive into this a little bit deep, but it's by design because I really want people to understand, if I can go out there and find, what things actually are supposed to mean, any guy can do that, and it doesn't take somebody with a law degree to be able to spell this out. You know what I'm saying? So I don't know. I mean, that's kind of my thing, but I also want to enjoy my time with you guys and playing games. So hopefully we can go back to that. So, and my voice is going out again, and I've run out of water. So that's my cue to end the stream. Everyone have a great morning, afternoon, or evening, whatever the case may be. Please stay safe, stay hydrated, and we'll see you on the flip side. If I can fix my computer, I'll do Enshrouded tonight. If I can't, I'll reschedule it to later on next week. Okay, guys? So please take care. We'll talk to you soon. Until then, this is Marko Yamashita signing off. Peace.
I like to get paid, that's why I work every day. I'll be making money till I'm in my grave. Don't care what they say, I'll buy time with my money. Laughing to the bank cause it's funny, the money keep coming.